Yes, good morning, everyone. You may have a seat. Have all the technological challenges been worked out? Okay, all right, and we're ready to proceed?
Yes, Your Honor.
Your Honor, we may approach for a quick briefing.
Certainly. Further that the court has to address before we bring the jurors in?
Nothing from the state.
I believe there was one more thing. Listening to the 911 tape again last night, and I know probably should have been objected to the first
Could you
time.
turn on your mic, please? Turn on your mic, please.
Court reporter can't hear what you're
Hello.
saying.
Hello. Okay. Yes, ma'am. Early in this case, when Judge Malone received the case, I went to go have a bond hearing, and the grounds for the bond hearing were to reconsider. Plus, the 911 tape appeared to have a 2-second gap that was unable to be explained why. The 2-second gap, you could hear from the video where it started and then where it came back in. And it came back in 14 seconds later when there's only a 2-second gap. So I was unaware of why a 911 tape would have a gap like that. And how do you fit 14 seconds into 2 seconds? During that hearing, I think the state stipulated that there is a 2-second gap where 14 seconds should be in the 911 tape. And I believe it's the one that's been presented here. I listened to it again last night just to make sure that the gap was still there, and it appeared to still be there. So I would object to being played again based on the fact that there is an issue with that 911 tape. I don't see procedurally how I could come back and try to have it redacted or taken back out of evidence. But I wanted to make the court aware of that gap that was there when it was discussed in the procedure of this court, not this court, but the previous court, and what was addressed and what was stipulated to. So I'm not sure how we would go about, and that's what I was looking for, some kind of law or something to present the court that would be able to stop or take the tape out because it has been altered with. The 911 custodian who got up on the stand said there was no way really to alter it in any form or fashion. However, it was altered, it appeared altered. When I addressed it early on in this court proceeding, The state didn't have an answer either, and they just stipulated that, yeah, there's a gap, and yes, there should be 14 seconds in there, and if necessary, we could, I guess outside the jury's presence, play it, and I can tell you exactly where it is, and you can compare it to the video and see where the gap is and what should be there and played, but was not.
Any response from the state?
Sure.
I'm not sure what he's talking about as far as stipulating to anything. Judge, the foundation for those calls was laid. The witness testified unchallenged about what could and could not be done to the calls as they come into the call center. When I tendered them into evidence, there was no objection. And so those discs are fully in evidence and can be played for the jury. And I don't think it's appropriate for defense counsel to try to argue that it's been altered, because that was the testimony that was elicited, that it hadn't been, and then he did not object. And it's too late to go back and try to claim alteration and things of those lines. He's had these discs for 4 years. 4 years. If there was something incorrect about them, he could have certainly brought his own expert. He could have done something. He could have objected. None of that has happened. The calls are in evidence, and they can be played for the jury at this point, and we're going to play them this morning with the court's permission, obviously, as we discussed last week. And to try to come in now and claim that they've been altered when he didn't object or lay any foundation for that, there's literally zero evidence that there's anything wrong with these calls. There's a lot of operators in a 911 call center. If there's other noises or anything else that's going on in the background, it is what it is. But the calls are in, and I think this, I don't know what it is, but this, I don't know if it's an objection or this argument is overwhelmingly untimely and without foundation.
And I would refer the court back to my motion to reconsider bond back when they put Ms. Payne back in jail because it got indicted. The case got indicted within 4 or 5 weeks, an unheard of time. And my motion was filed, and in that motion, it did describe what was heard on the tape, what the concerns were. And the prosecution, or the assistant ADA at that time, came in and said she would stipulate that there's a 2-second gap where a 14-second video had appeared to be what should have been there. So this all should be on the record based on my previous motion that I filed with the reconsideration of a bond motion. It was heard, and it was decided that she would get a bond based on maybe some discrepancy or something being altered. So there was a bond given based on me playing the audio and playing the video at that time, and the ADA, it wasn't foul, it was I guess a stand-in, and she stood there and said, I stipulate there's a 2-second gap where 14 seconds should go in. And the judge made that decision to give her a bond based on me presenting that evidence. So there should be record of it. There should be a motion filed that described it, and there should be an order where she got a bond based on that. So there is record of this. And once again, as for timely, I guess I should have caught this earlier, but I wasn't sure which 911 because it had been so long ago and the court had already made a decision on it. So that's why I was looking for the law to see what I could bring in to use to bolster my argument, besides just saying I want to bring to the court's attention that this 911 tape had been altered.
Okay. Are you checking, going back?
There's a transcript, but again, it doesn't matter. Before this jury, the state laid the foundation for those calls, laid the foundation for any ability to alter them, tendered them, and they were admitted without objection. So if he had an objection, that was the time to make it. That is what I mean by untimely. If he thought 4 years ago there was a problem with the discs, then something should have been done for trial. That was not a trial motion, and there's literally zero evidence that she got a bond because of a gap in a 911 call. Zero evidence of that. She got a bond because she'd already had a bond, and when we re-indicted her, she was rearrested. She'd already been on bond. So that is an attempt to mislead this court, and that's not why she got a bond. She got a bond because she already had one, and had already been out, and the judge just basically reset the bond and put her on an ankle monitor.
That is incorrect, Your Honor. She denied a bond when she got rearrested. We went in front of the court and asked for a bond. She was denied a bond. And the judge was hesitant to allow that bond until I filed a motion to reconsider, and I brought evidence in there showing that there was a gap in this statement. There had been some kind of alteration of this document. And at that time, she decided to give her a bond. And it was a much higher bond than she already had done. So she had to keep that bond that she already paid for intact and pay an additional $300,000. So it was not given because she already had a bond. That was my first argument to get a bond, was the magistrate judge came to the conclusion that she was eligible for a bond and gave her a bond. Why would this court deny a bond? So I had to bring it back up in a motion to reconsider. And I put the facts in there of the tape being altered.
Okay. If I may, Judge, I have the transcript.
Okay. The transcript of
The bond hearing, yes, Judge, where it was fully explained. And it was ADA Fowler.
Then obviously that's the wrong. Mine was the motion to reconsider, not the original motion to bond.
By Mr. Fowler to the 911. It was a different custodian of records. Can you kind of just briefly explain to us what's going on during that silent period? The explanation. The way that the server works, that this audio was saved on, the best way to describe it is it's similar to a voice-aux recorder, if you're familiar with those. It only records when there is actual activity above a certain level. In other words, if you have a voice-aux tape recorder that you used in college, if you set it on a corner of a desk to record a seminar or something, if there's a pause in the lecture while the instructor takes a breath, for example, that recorder may stop. Question. So it's not as though the audio was edited to cut something out. It's just that the system can't hear, and so it stops for a moment. Answer. That's absolutely correct. It has not been edited in any way. And I'm trying to look through Mr. Tucker's cross-examination of that foundation witness.
And Your Honor, this is not the motion I'm talking about. Mine is the motion to reconsider bond in front of Judge Malone. Fowler had already left by that time.
This is in front of Judge Malone.
And Fowler had already left when I did the motion to reconsider.
No,
that specifically discusses what the issue you've raised, Attorney Tucker, unless you raise it again, but that specifically addresses what you're claiming is 2 seconds, but really extends into 14 seconds.
What I was addressing there is it sounded like it was radio silence. And I was asking, is it common to have radio silence instead of hearing what is being recorded? And the one to be considered addresses exactly a 2-second gap where when you see it on your computer, it drops and then comes back, the ball underneath it. And I asked specifically why there would be a gap taken out that has her in the back in the video screaming stop, 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 whereas the audio of the 911 has none of that. And then it comes back right with, oh my God, ma'am, he just pulled the trigger of my gun. It was a gap that had that part taken out. And when I asked the state about it, we brought it to the judge's attention. There should be transcripts of it.
I'm holding the transcript. This is the motion to reconsider bond after indictment. I'm holding it.
No.
I'm reading from it. It's in front of Judge Malone. It's in July of 2019. That's the discussion about the 911 call.
And that was the motion to reconsider.
Fowler was not present at that motion to reconsider. And I'm trying to pull up the case summary so I can get the exact date of it.
The only other motion to reconsider, Judge, was a motion that I argued when she asked to have her ankle monitor removed. That's the only other. That's the only other hearing. But this is the motion because, as the counsel is pointing out in his opening of this motion, she'd already made the bond. She'd already started her life again, and then they indicted her and added charges. So this is the motion to reconsider. And the 911 call is discussed and very clearly explained. So his answers to that question, he's already been provided the answer to that question.
So there was a motion for reconsideration of bond briefing support July 29th, 2019, and then there was one July 1st, same thing, but then emergency motion for reconsideration bond and briefing support thereof. So was that the July 29th?
I think that's when you would see it being filed. The hearing, it looks like, occurred on July the 12th. Sometimes there's a delay in the filing if you're looking at CPUA.
And then that motion to reconsider was denied, it seems, the 7th of August, 2019.
So there does have to be another one, because if it was denied, we know she got another bond. I don't know when that one was.
Okay.
But the answer to the question about the 911 call has very clearly been answered. There's only one witness who has testified to the foundation of the 911 call, and it was admitted without objection. So I think it's just too late. They've already heard it. It's in evidence. And he has no good faith basis and no foundation and no evidence in order to be able to argue to the jury that it's been altered. There's no good faith basis to do that.
Your Honor, I have a good basis. If you would like to hear the 911 tape and look at the video, I can show you exactly where it cuts off. And you can hear, if you watch the video, you can see where the video shows the part that's missing and then comes back in with her screaming, man, he just shot himself and pulled the trigger of my gun. There's a gap, 2 seconds. And then there's 14 seconds of that video that should be there. So there's your good faith good faith basis. And that is what occurred, and that's what I argued on the motion. The latter part to get a bond. And upon hearing it in court, the judge came to the conclusion that she would get a bond because it appeared like there was some kind of alteration of the 911. As for talking to the 911, Tim White, or the custodian, I was asking specifically why there was radio silence and why there was no one talking during that period of time that they're supposed to be telling her not to chase. And then I asked about the other tape, and Alan went through it methodically and said, these cannot be altered, but yet it appeared to be altered. And that was my argument. That was in front of Judge Malone, and that's what gave the basis for her to give a bond, which, like I said, was an extremely large bond since she'd already made one. And that was my understanding as she turned and said, okay, we're going to give her a bond, but it's going to be this amount. So I know I can't do anything about it being submitted into evidence, but if there's some way to, upon the court's approval, explain that there is altercation, if we need to play it for you to come to your conclusion of it, I have no problem with that.
And this court is not a finder of fact. The court can't find that there's alteration. There is no alteration. It has been explained. The only evidence before this court is that it can't be altered once it's saved on their system. And then his question about those quote-unquote gaps are explained, because if there's not a high enough volume level, then it stops recording. It's been explained. There is no mystery here. There is no conspiracy here. Nothing has been altered. There's no evidence of that. And it's in evidence, and we just need to deny what, I don't know what motion this is, but it's in evidence. The jurors can listen to it as many times as they want to. And that's all there is about this.
Okay, let me ask you, Attorney Tucker, can we play that specific portion?
Sure. I think we went through and tagged exactly where it was, and then, like I said, you can hear where there's a gap, and there's nothing to play. And then all of a sudden, it pops back up with her saying, ma'am, you just pulled the trigger of my gun. But if you hear where it stops, and you put the video where it stops and listen to the whole video, you'll see there's 14 seconds of that video, but there's only a 2-second gap. That's why I was asking about Tim White, to find out when he was going to be here, if he was going to be here. He was the one that was the custodian, the head of it at that time, who would have to explain. So if the court would like to hear it, they can cue it up, we can cue it up to where it's at, and then compare it to the video. And in the video, you're going to hear her screaming, stop, stop, stop. In the 911 call, you don't hear that at all. And you hear how loud she is, and you see where that phone is right there below her. You would think it would catch that audio, but it doesn't.
But there's an explanation that if it doesn't rise to the level where it can be recorded, then it wouldn't be. But here's what I'll do. If we can just quickly to play the video with the audio to see what it is that you're trying to establish, Attorney Tucker.
We have the IT.
Ben is here. Ben can. Thank you, Ben.
You want us to turn down the volume to get it right to the slot, or does the court care?
Or if you turn up the volume so we can hear
Right.
if there's a pause.
Okay. So we're going to go to where the pause is. I didn't know if you want to hear all that.
Well, just something preceding that lets us know that there is a pause.
Okay. So, if you can go.
All right, Senator's right.
Ma'am. Ma'am.
There. And we believe it's this gap that there's a radio silence that you can hear her talking all the way up to it, and boom, it stops.
Ma'am.
Right there. believe is where that click was that we heard. And you hear click, and then there's nothing, and then boom, you hear ma'am.
Okay.
So,
And where's the video that corresponds?
we're going to put it on. So at 3:49 in the recording, you click, and then boom, all of a sudden you hear ma'am.
Ma'am!
Yeah, that goes to the video. And you can hear her in there screaming, stop, stop, stop.
Hey!
And you hear some ma'am. And you can place it. As you can hear in the background, the speaker saying ma'am. You just pull the trigger. So go back one more time. So part of this is yours to stop.
Hey!
So that portion, 14 seconds, and it was a 2-second gap that appeared to have a click, and then just her coming back screaming, "Man, you don't hear any of the stop, stop, stop." And that was the concerns of what we raised at the bond motion, and the ADA that was handling it there. Once again, she was not as familiar with the case because Fowler had just left, but that was one of the bases we brought up, that she agreed with us and told the judge. The judge watched it, listened to it, and then issued the bond.
Okay, so that was perhaps a bond issue. The court does find that the tape has not been altered. There has been a witness here that has said that what was presented was not altered. The court believes that witness's testimony. I'm not sure what you're trying to establish with respect to the video and the audio, but there has been an explanation that was read with a transcript where they're saying when there is no activity to be recorded or it doesn't rise to the level that it can be recorded, then there would be silence. And so the court finds that it has already been published to the jurors, and there was no objection at the time. The court finds that the objection at this time is untimely, but that there's not necessarily a foundation for the court to find that it shouldn't be republished to the jurors at this time. So it will be republished.
And I can bring to the court's attention from the testimony I wrote down that if it was altered or changed, it would have been somebody above her who had the custodian of it, and asked, would that be Tim White? And she said Tim White was her boss and would have been in that position. I do have Tim White under subpoena, and I guess we'll address it then.
Okay, all right. If you determine that you need to call Tim White, then certainly the court will allow you to do so.
Yes, sir.
Okay, thank you, Attorney Tucker. Okay, anything further that I need to address?
Nothing from the state, Your Honor.
Okay, anything further, Attorney Tucker?
Nothing for the defense, Your Honor.
Okay, thank you. We can go ahead and bring the jurors in. be seated. Good morning, ladies and gentlemen of the jury. I hope you're all well today. Happy new week. You look refreshed and ready to listen to the evidence again this morning. The state will proceed at this time to call its next witness.
State calls Ashley Jackson.
All right, Ms. Jackson, are you able to remove your mask?
I am.
Thank you. Could you raise your right hand? Do you swear or affirm that the testimony that you will provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can have a seat and pull yourself up to the microphone. All right, will you please state and spell your name for the record?
It's Ashley Jackson, ASHLEY, JACKSON.
And Ms. Jackson, are you a resident of Clayton County?
I am.
And how long have you been a resident of Payne County?
All my life.
All right, and are you familiar with the area of Forest Parkway at the intersection of Riverdale Road?
I am.
Now, is that location in Clayton County?
It is.
And were you in the area of Forest Parkway and Riverdale Road on May 7, 2019?
I was.
And why were you in that area that day?
I was getting off work.
Okay, and about what time would that have been?
A little bit after 6 p.m.
Now, where do you work? Like, actually, where is it located? Where would you have been coming from that day?
Atlanta South Parkway.
And is that connected to Forest Parkway?
It is.
Now, can you explain what happened as you turned off of Atlanta South Parkway onto Forest Parkway on May 7, 2019?
I was getting off work. As I was approaching Forest Parkway, I was making a left off Atlanta South Parkway. As I was making my left and getting into the far right lane, Miss Hannah was coming up Forest Parkway. She was coming from the end off of Highway 85, and she almost ran me off the road. She was speeding. She was going very fast. When she almost ran me off the road, my coworker actually called me and was like, "That car almost ran you off the road." And I said, "Yeah, she's probably going to cause an accident." So I proceeded up Forest Parkway. She was weaving in and out of traffic. Once I got towards Riverdale Road, I saw Miss Payne had caused the accident.
Now, when you say she was weaving in and out of traffic, were you the only car that she almost ran off the road?
The right lane really didn't even have any cars in that lane, but she was still going like left, right, making other cars hit their brakes.
Now, as you got closer to Riverdale Road, when you said you saw that she caused an accident, can you explain to the jury what you actually saw?
As I got to Riverdale Road, traffic was everywhere. Well, traffic was stopped. It was just one of those days that it was just very busy. There was already something going on at the highway. People were out walking all over the place. And she had maneuvered her car in front of another vehicle and stopped them and caused the scene.
Now, do you recall if they actually collided at the point that you saw?
I don't really believe they actually collided. I'm not sure. I don't want to say something that I didn't see.
And once you saw the defendant's vehicle cornering the other vehicle, what did you, if anything, did you see her do?
I saw her at the driver's side door of the vehicle, yelling obscenities for the man to get out the car. It looks like she was trying to fight him through the window.
And what was her demeanor at this time?
Very aggressive. Very aggressive.
And what made you kind of stop at that time?
Because she was yelling, get out of the car, MFer, like banging at him like this, like get out of the car. So it was the big scene.
Now, do you recall if the victim's window was up or down at that time?
I want to say his window was down. I can't recall if it was all the way down, but it was down. And she was like trying to fight him through the window.
And when you say she was trying to fight him through the window, what did you actually see?
I just saw her hands moving, get out of the car, motherfucker, doing all this. I never saw anyone's hands come out of the window, per se, but I did see her at the window.
And could you see anything that the victim was doing inside of the vehicle at that time?
I couldn't see anything he was doing inside the vehicle. I never saw his hands come out of the vehicle from where I was.
Now, after you observed her hands moving and telling the victim to get out of the vehicle, what, if anything else, did you see?
Her pull a gun. After she pulled the gun, she shot him and she said, now you need an ambulance.
Now, when she pulled the gun, when did you hear the shot?
Immediately.
Now, were you able to observe any of the victim's demeanor during the entire incident?
No.
And do you see the person who shot the victim in the courtroom today?
I do.
Can you identify them by an article of clothing they are wearing and identify where they're sitting in the courtroom?
She's sitting directly in front of me wearing a blue shirt.
Let the record reflect that the witness has identified the defendant in open court.
The record will reflect.
Now, did you know the defendant prior to the incident?
No.
And did you know the victim prior to this incident?
No.
Now, after the victim was shot, what happened?
He just laid back in his seat. His eyes went white. He just laid back. She stood back. I think everybody ran towards her. I think I even came towards her and I was like, oh my God, you shot him. Somebody else waved down a police officer. He was already at the exit. The officer came running up. He said, what happened? Who shot? She tried to say that he grabbed her gun, but everyone immediately said, no, that's not true, because that's not true. The man never grabbed her gun. And he put her in handcuffs.
Now, what was the defendant's demeanor immediately after the victim was shot?
She had no remorse. She was just she was thugged out. She had no remorse at all. She was so right in that moment. She felt like she had done something.
Now, did you ever see the defendant attempt to render any aid to the victim?
Not at all.
Nothing further, Your Honor. Take cross-examination, Attorney Tucker.
Mr. Jackson, my name's Matt Tucker. I'm the attorney for this thing. I've got a few questions to ask. You stated that you were coming home from work. Is that an accurate diagram of where it occurred in front of you?
Yes.
Okay. Could you show me where you saw the accident happen and where you were positioned?
I was coming from this way.
Mm-hmm. And which way were you turning?
I was going to make, this is McDonald's, I was going to make a turn this way to go down Lisbon Road.
Okay. Had you already,
So I I saw the accident here. I ended up being back here. She was like right in here somewhere. It was right in here somewhere. So it was maybe 1 or 2 cars in front of me.
Okay. And so how far would you say you were from the accident?
I was literally right there. I had pulled my vehicle around another car so I can get a good glimpse because I was trying to record it, but it happened so fast I couldn't even record it.
And you stated you were right there beside him on the left side of it, on the right side? Do you recall?
I wasn't right there beside them, but I was right there. I wouldn't say I was right there beside them.
Yes, ma'am. Already been put into evidence. 5, 6, and 7.
Yes.
These are pictures of the accident that have already been put into evidence.
Okay.
Okay, so as you see that, and where were you at in relation to that position?
I had to be probably back here a little bit somewhere. I had pulled my vehicle over this way so I could see.
Okay, and I'm going to put one on the screen.
Okay.
And you said you were where about?
Probably right up in here somewhere I pulled my vehicle. Oh, okay.
Would that other picture be a better picture? That shows more of the road.
My vehicle is over here somewhere by these white lines. I pulled my vehicle over here.
Okay, if you could, do you see on your screen?
Mm-hmm.
All right. You should have the capability to circle and a color will come up. Can you circle where you were?
Over in this area right here, over here.
Okay. So you were coming off of Riverdale Road or Forest Parkway?
It's coming off Forest Parkway.
Okay. And you see the diagram there that shows the roads. So you were behind them. You were behind the red truck.
I was 1 or 2 cars behind the red truck.
Okay.
When I saw the accident, I pulled over that way. I pulled my vehicle up this way so I could see traffic was stopped.
Okay, so when you pulled did you kind of pull on the sidewalk or to the side of it?
I pulled where I circled it. I pulled over that area.
Okay, so you were closer to the median.
I pulled right there where I circled it.
Okay, ma'am, if you look at the other picture, do you see a median?
I do see a median. So
Okay.
that's where I pulled it. I pulled over that way.
Okay, and
So I could get a better look. I was trying to record, but I couldn't get my camera open fast enough because it happened so fast.
okay, so you pulled over there on the other side of the truck or the Jeep. Was there any traffic or anything stopping anybody from going that angle? To pull
Traffic
up?
was stopped. There was a traffic jam. There was something going on at the highway. Nobody was barely moving. It was a little traffic moving, but nobody was barely moving.
Okay, and you said that she was cutting in and out of traffic.
Coming up Forest Parkway.
Okay, and you said that she cut one of your coworkers off, and that coworker.
No, she almost ran me off the road, and my coworker was behind me, and she called me and she said, "Dang, that car almost ran you off the road." And I said, "Yeah, she probably gonna cause an accident."
Okay, now, ma'am, do you recall having a meeting with the detectives on this matter?
I did come in for an interview.
Okay, and in that interview, do you recall speaking with the detectives?
Yep.
Okay. And in that interview, do you recall telling them about the incident as you just described right there?
Yes.
And in this interview, to the best of your knowledge, do you recall telling them that he almost ran my coworker off and never once mentioned that he almost ran you off the road?
That's not true.
That's not true, okay.
I said she almost ran me off the road because that's what happened.
If I may approach your Honor.
Yes, you may.
What I hold here is the transcripts of your interview with the detectives. If you could look at that to refresh your memory of what was said that day. And particularly what I'm asking, and you have, please take your time to look at whatever you want to in that, but I'm particularly looking at page number 3.
Page number 3?
Yes, ma'am. It is where Detective Chapman is saying, is she coming from behind you?
That's not what page 3 says.
Did you have more than one interview
No.
with the detectives? If I may approach your Honor.
You may.
I think it was in more detail. Page 4, so look at page 3 right here. There you go. Okay, there you go.
Okay.
If I could bring your attention to where it says, so she came from behind. I didn't even see her coming, okay?
Mm-hmm.
And then Detective Chapman says, sure. He said, one of my coworkers.
Oh, hold on a second, Attorney Tucker. You have to articulate.
Okay.
Because our court reporter has to record and we can't record.
Okay.
Thank
And it says, one of my coworkers, she was pulling up behind me and she says, dang, that car almost ran me off the road. And you said, yeah, that crazy bitch is going to cause an accident. You recall saying that?
Yes.
Okay. Do you recall saying, and you can look to refresh your memory, that you said that she almost ran you off the road, or did you use the comment that your friend said, your coworker?
My coworker called me and she said, dang, that car almost ran you off the road. And I said, yes, that crazy bitch is going to cause an accident.
Now, can you look at the statement I was saying right there where it says Ashley Jackson? It says, one of my coworkers, she was pulling up behind me and she called me and says, dang, that car almost ran her off the road. Not you, her. Is that correct?
I said what I said. I'm not sure why it says her, but when I said it, I was speaking in third person. Like, my coworker's calling me saying, dang, that car almost ran you off the road. So I'm not sure why it's typed that way.
So you're saying whoever listened to this audio of your interview inadvertently put her instead of you?
Could have been.
Okay. And you do recall saying, yeah, that crazy bitch is going to cause an accident?
Yes.
Okay. So at that time, you had decided because of her driving that she was a crazy bitch, correct?
Yes.
Okay. And
pretty much.
Okay. And you didn't know what was going on. You didn't know why she was driving that way. You just assessed that that's who she is based on that driving.
She was speeding up the road and she almost ran me off the road. So that's someone's natural reaction. So I'm not judging her per se because I don't know her, but that's someone's natural reaction when someone almost runs you off the road. You're like, dang. So yes, that is my comment. And that's what I said at the time.
Now you said there was traffic everywhere. Everybody was stopped and it was real slow, correct?
Once we got to Riverdale Road, it was stopped. But while we were traveling to Forest Parkway, the traffic was not stopped. We were still moving.
Okay. So it's fair to say that there were still cars moving and that cars could go around that accident either to the right or to the left, correct?
On Forest Parkway?
Yes, ma'am.
Once you got to Riverdale Road, you really couldn't go because there was traffic, so you had to wait.
So how is she weaving in and out and going past you if it was traffic stopped right up there?
So Atlanta South Parkway and Forest and Riverdale Road are a little ways from each other. So she was weaving through traffic going up Forest Parkway. Once we got to Riverdale Road, that's when traffic was stopped.
And could you show me on that diagram that's right there? You can stand up and show it, please.
What do you want me to show you?
Show you the direction of your travel and the direction of her travel.
We were coming from here, going towards here. This is where traffic was stopped because the highway is, I think this is the highway maybe? I'm not sure. Wherever the highway is, there was a incident. Like I said, the police officer was already on the scene. So traffic was very heavy here in this area. Nobody was really moving. But coming up Forest Parkway, we were able to move.
Okay. And so you're coming this direction, correct? Down that road, as you said.
Correct.
Okay. And the accident was where? You said was...
The accident was in here. The accident was in this area.
Okay. So, as you see that turn lane right there, he appears to be turning right on to Riverdale Road, correct?
That's correct.
Okay. And you're saying she came around and cut him off up there where he appears to be turning right, correct?
That's correct. You see how her
And
vehicle
you were turning left, correct?
I was going to turn left, but when I saw the incident, I got behind them because I wanted to see what was going on.
Okay. So you're behind them and you're saying you're at the meeting, correct?
So there was maybe 1 or 2 cars in front of me initially, but once I saw what was going on, I pulled my vehicle over because I wanted to see. I was trying to record.
All right. And
I didn't know all that was going to happen.
What happened to the 1 or 2 cars that were in front of you?
They still were there. I moved my car out. Like I told you, I pulled my vehicle out so I could get a better view.
Okay, so using this picture here, can you show me where the 1 or 2 cars were positioned?
They were over that way.
Maybe if you could use the screen, you could mark
They
it.
were over this way. They were over here.
Okay.
I pulled my vehicle out.
So it's fair to say that where they were at, it was clear they could pull up there, or they could keep going past it, or get around that.
Nobody could go once she did that.
Excuse me?
Nobody could move in that lane once she did that.
Okay, in that lane. But was the area, you see where a walkway and all that area is it fair to say that that was clear? They could have drove around the vehicles?
On the sidewalk?
Yes, ma'am.
Who was driving on the sidewalk?
I'm asking, is it possible they could have gone around the traffic, around that, on the sidewalk? Was it clear?
Who was driving on the sidewalk?
Ma'am, I'm asking you a question. I'm not here to answer
I'm not
questions.
going to say somebody was going to drive on the sidewalk. I'm not understanding why
I'm
somebody would
asking
be
you
driving
a
on the sidewalk.
clear question. Is it possible for somebody to have gone up on that sidewalk and drove around the accident? Whether you would do it or not, was it possible?
I'm not sure.
Okay. And you said those two cars pulled over there.
Those two cars were, it was one or two cars over here. I pulled my car out at an angle so I could see.
And that would be at the kind of the top of the area.
Kind of where I circled it over here. That's where I pulled my car over in that area.
But on this, you're saying that they're turning right, going upward, correct? Following that flow of the diagram.
What are you asking?
If I may approach you. According to your statement, you're saying they're coming this way, going this way, correct?
That's where the accident happened.
Okay, so they're going this way. And you say you pull over here at the median. And they're right there, correct?
Pull over this way, right over here, so I can record.
So right in this area here.
So wherever this is right here, I pulled right here.
Okay. And you said you got on the median, you went reaching for your phone, correct?
I was still looking. I was trying to fumble with my phone like this, but I could never get my recorder out. Get my camera to come on. It happened so fast.
And this is why you were talking to your coworker on the phone, correct?
Nope. I was talking to my coworker on the phone back on Forest Parkway when I first pulled out. When I got to this point, me and my coworker were not on the phone. I was looking. I was trying not to miss anything. I was trying to hurry up and get my camera to come on, but I could never get my camera to come on because it happened so fast.
All right. And do you recall looking down further where the Detective Chapman said right? Would you have said the same thing? And you said right. So there's no cars in this lane, but there's cars in this lane. Okay, which lane are you talking about?
So in the right lane on Forest Parkway, there were barely any cars, but in the left lane, like she could have just went up that lane, but like I said, there were cars in the left lane. She kept weaving through traffic. That's why I said that.
All right, so where she's parked right there, it appears she's come over into that lane, you say the right lane, correct?
Okay, so when I turned off of Atlanta South Parkway, it's further ways from Riverdale Road. So she didn't have to weave in and out of traffic. That's what I'm saying. She kept weaving in and out of traffic. There was no need for her to do that. She could have stayed in the right lane.
All right, and as you said, she's weaving in and out of traffic.
Yep.
Was she in that turn lane, or was she in the lane going straight?
She was out my sight by that time. By the time I got down to Riverdale Road, she had already caused a little accident and was out at his window. So that's when I saw her, when she was out at his window.
Okay, so you didn't see that maneuver or whatever they're saying. You didn't see the Jeep pull in front.
No, I didn't see
it.
how she maneuvered and landed in front of him. I just knew that's what she did. By the time I got to Riverdale Road, she was already at his window, fighting him and doing all that.
So you don't know if another car caused her to go into that direction. You just presume, because she was a crazy bitch driver, that she did that, correct?
Nobody caused her to go into that vehicle.
But you said you didn't see it.
No, I didn't see it.
So why are you so certain that nobody caused her to do that?
Because nobody else was on the scene.
Okay.
Nobody else was in an accident. Nobody else was in an accident.
All right, so you're saying that the red truck hit her car?
It's not what I'm saying.
Okay, what are you saying?
Listen, I don't know how they collided, so I never said anything about that. So I don't want to answer any questions about that because I never said how they collided. When I got to Riverdale Road, that was the scene.
Okay.
And I saw her at his driver's side window fighting him and cursing.
So you never saw her exit the Jeep, and anything that occurred, you only saw her at the window, as you said, banging on the window or banging on the truck, correct?
She was banging at the window. I thought she was banging at the window at first, but then I realized she was like attacking him through the window.
Okay. And you said attacking him from the window. So the angle you have, if she's at the window, you can't see who's inside the truck, correct? Is that fair to say?
No, I could clearly see.
You could clearly see who's in the window at the angle you were at.
I could clearly see.
And you were in the driver's side of the vehicle that you pulled over in that meeting, correct?
Correct.
Okay, and from that angle, with her standing at the window, you could see who was in the vehicle and what was going on.
I could see her at the vehicle. Her arms were moving like this. Get out of the car, MF her. She pulled the gun out and shot him. I could clearly see.
And you are positive she was saying MF.
Very positive.
Okay. You wasn't saying anything else, but positive that the curse word you heard was MF.
Yes, she was saying get out of the car, and then she shot him, and then she said, now you need an ambulance.
All right, and you said that she shot him. How did she shoot him? Did you see the shot?
I saw her pull out the gun and shoot him.
So she pulled out a gun and pow, shot him?
Yes, in the midst of the situation she had going on, she pulled out the gun and shot him.
Okay, and she pulled out the gun. Was she outside the vehicle when she pulled out the gun?
Yes, she was at his driver's side door.
And then she shot outside the gun, outside the car or the truck?
Yeah.
Okay.
Yes.
So your testimony is that you pull up to the median, stop. From that angle, two cars are in front of you that move out of your way. So
those cars never moved out of my way. I pulled my car out to the side, like I said, to get a better view so I could record.
And you said the other two cars pulled over to the side, correct?
I never said those cars moved.
You just drew a line up there, man.
I said those cars were already right there.
Okay.
I never said those cars moved.
But they were in front of you at one point.
They were, and I pulled my car to the side.
Okay. So you pull your car to the side to see it. You're grabbing your phone trying to figure out how to record, correct?
That's correct.
And during this process of trying to figure out how to record, you're watching her and seeing the individual inside that truck.
I watched her the whole time. I was trying to like move my fingers by memory. I could never get my camera to open. It happened so fast.
Okay. But during that period of time, you're trying to get your phone to do a recording. You're looking.
Your Honor, asked and answered.
I'm
Asked the same question multiple times, and she has answered the question.
Your response, Attorney
Your
Tucker.
Honor, she has not given a definite answer of, and my question would be, if I could finish it, would it,
Finish your response.
okay, I have not finished my question, Your Honor. I was going to talk about the face she said she thought she saw, and I was going to ask what was the demeanor of the individual inside the truck.
Okay, I'm going to sustain the objection. She's asked, she has been asked, she's answered the same question several times. Now you can move on to your next question, but she has answered.
And I would respectfully request the court. I never asked what the demeanor of the driver's face was. She never answered that.
Next question.
Okay. What was the demeanor of the person inside the truck face?
I never really saw his face until afterwards. Until after she had shot him and everybody was out the car, everybody was trying to see if he was okay. That's the only time I really saw up close of his face.
Okay, and then when you stated that you remember hearing her say a comment of now you need an ambulance.
Correct.
Okay. Was that before or after she was on the phone with 911 requesting an ambulance?
I never saw her call 911 for an ambulance. When she shot him, she said, now you need an ambulance.
Okay, and so after she shot him, you said she walked away and did not pick up a phone?
She never walked away.
Okay, did she pick up a phone?
I don't recall her picking up a phone.
And
I never said that in my statement.
Ma'am, I'm asking you from your memory and seeing what you...
I don't recall her walking away and picking up a phone.
Okay. Do you recall her calling or talking or overhearing her say...
I do not recall her picking up a phone to call an ambulance.
So it's fair to say that when the incident occurred and everybody is stepping up to see what's going on as the congregation gets around the truck right there. You're telling me you didn't hear her make any other comments besides now he needs an ambulance?
After she shot him, she said, now you need an ambulance. She was
And-
talking to him. She wasn't talking to, she was fighting with him. And I felt like she couldn't handle him the way she wanted to handle him, so she pulled
Your
out
Honor, I
her gun
object
and she
to
shot him.
her making comments of what she thought. That's speculation.
Okay.
Okay,
So don't comment about what you thought, just respond to his questions.
Okay.
but, Attorney.
Okay. Now, you stated that in your testimony, if you want to go to page 7 to refresh your memory. And if you look below where Detective Chapman says, okay. Your comments were, she said nothing. The police officer finally came from the exit. And he was like, who shot who? Everybody's like, she shot him. And the first thing she said is, I didn't even have my finger on the trigger, but he reached for my gun, but I never saw his hands come out the window.
That's correct.
Okay. So you're stating that you overheard her say, I didn't have my finger on the trigger, but you're saying you never saw his hands come out the window, correct?
That's correct.
And she was outside the window shooting at him, correct? That's what you said?
That's correct.
And another guy was like, hey, I got it recorded, correct? You remember that?
Somebody did. I think somebody did say that.
Did you ever get to see that recording?
No.
And basically you were in the crowd that everybody was saying she shot him?
Yeah, when the police officer came up from the exit, he asked what happened. She tried to say that that she didn't pull the trigger. He was trying to pull her gun, but I never saw him do that.
Okay. And do you recall, if you can go to page 10, do you recall saying that she pulled that gun out and shot him immediately? And the detective said, sure, she was pissed. She was so pissed, like she was mad as hell.
That's correct.
Okay. So you're saying that she pulled the gun, pow, immediately shot.
She did.
And that's what you saw from the angle you were at right there at the median, correct?
Correct.
All right. Did you ever move your car from that median?
After the whole scene was over with, yes.
Okay. And where did you pull your car to?
I really can't remember.
And you stated on page 12 of your testimony to the detective you said, I did see the gun outside the window when it was fired. The detective said, did you see the gun outside the window when it was fired? And you said, yes, I could see it. I could see her shooting the gun.
Yes.
Okay. And earlier you said at that thing you didn't see her shoot the gun.
It's not what I said.
In your testimony we were having just a few, when the state was asking you a question, you don't recall saying that I didn't see her shoot the gun?
I saw her shoot the gun.
And did you write a statement on that day?
I did.
They're going to have to redact the information. Let me give a shot real quick.
Yes.
You have a black shark in there. I may approach, Your Honor.
You may.
If you could look at that document there and tell me, does that appear to be a true and accurate representation of the document you wrote that day?
Yes.
Okay, is that your signature there at the bottom?
Yes.
At this time, Your Honor, I'd like to tender defense exhibit number 38.
Any objection?
No objection.
I can see without objection.
And now, if I may approach.
Yes, you may.
Did you recall in this document ever saying that you saw her shoot him outside the car, outside the truck?
That's where she shot him at.
Okay. And you said that she jumped out screaming and punching the victim, correct?
Said she was outside of her car fighting the man at the window.
But in your statement to the police, you said she jumped out of her vehicle.
I said she jumped in front of the victim's vehicle, causing an accident.
And then what does it say after that?
She jumped out screaming, punching the victim. She pulled a gun and shot him. She was not even remorseful.
Okay. Now, you stated earlier that you did not see her get out of that Jeep. You only saw her beside the window.
How else would she have gotten to the window if she didn't get out her car?
Ma'am, I'm asking the questions.
Okay.
I'm asking you a yes/no question. Did you see her get out of that Jeep and approach that window?
I don't recall seeing her get out of the Jeep. Once I got to Riverdale Road, she was already there. To my recollection. It's been some years.
But your recollection of the time it occurred when you wrote that statement, you said that she jumped out of the vehicle and ran up to the window and started punching.
I would assume she jumped out of the vehicle. I never said she ran up to the window. I said she jumped out screaming, punching the victim. She pulled out a gun and shot him.
Okay. So that's not a true and accurate statement because you didn't see her get out of the vehicle, correct?
Well, that would be the only way she could get out her vehicle is to get to his window. She had to get out her vehicle to get to his window.
Ma'am, I asked you. That is not a true and accurate statement, what you said, because you did not see her get out of the Jeep and approach the window, correct?
Objection, Your Honor. Ask the answer.
There was no answer. There was a commentary without an answer. I don't mind her doing the commentary after she answers yes or no, but she never answered yes or no.
She answered that she did not see her get out of the vehicle. She answered the question.
Okay, I'm going to overrule the objection and allow Attorney Tucker to re-ask the question to the...
So that is not an accurate statement you wrote because you did not see her get out of the Jeep and approach the truck, correct?
It is an accurate statement, but I don't remember seeing her per se get out of the vehicle. But she was at his window, punching and screaming.
How can you say it's an accurate statement when you didn't see her get out of the vehicle?
Because I was there, I saw what happened.
But your testimony said you didn't see her get out of the vehicle.
No, I didn't. I don't remember her getting out of the vehicle, per se.
But you wrote on your document for the police that you did.
Because this was in 2019, it's now 2023. So I really don't recall if I saw her get out of the vehicle. I don't remember every little thing that happened. This was in 2019.
Okay. Now, from that period of time, have you watched the TV media regarding this incident?
No.
Okay. Have you talked to anybody regarding this incident?
No.
You haven't talked to the state?
Well, of course. I thought you meant outside of the state.
Okay, when I say anybody, that would include the state.
Okay, so I have talked to the state.
Okay, and you did have an interview with the detectives too, correct?
That is correct.
Okay, do you recall when those interviews were?
Not too long ago.
Okay. And your statements that you were saying in your interview were different than what you were saying that day, correct?
So they're not different. What I saw is what happened. What I said is what happened.
Okay. And what you said is what happened on that document or what you told to the detectives?
Both.
Both. And there's no doubt in your mind, because it has been 3 or 4 years, correct?
Correct.
There's no doubt in your mind She pulled the gun immediately, shot from outside the vehicle.
After she yelled for a little bit and screamed and tussled, she pulled the gun out and shot him.
And she was only yelling the MF, right? She wasn't saying any kind of cuss word. She was just yelling, "You MF."
She was yelling, "Get out of the car, motherfucker."
Okay.
Thank you, Attorney Tucker. Any redirects from the state?
Nothing further from the state, no.
Okay. May this witness be excused at this time?
She may.
Thank you. Does the state intend to call another witness?
Your Honor, we can have 5 minutes to set up the technology to play, to be part of the
Okay, certainly. Okay. So, ladies and gentlemen, the state has requested some time to set up the equipment so that they can republish, and so I'm going to give you a short break. It is now 10:56. We'll resume at 10:50. Sorry, 11:50.
To write what you say.
proceed at this time?
Yes, Your Honor.
Okay,
Yes.
thank you. You may bring the jurors in, Bailiff Ennis. Thank you. You may be seated. The court always appreciates the timeliness with which you respond to the time frames put in place. You may recall that at the beginning of the state's evidence that the 911 tapes were published, but the volume was low, and so the clarity was affected. And so the state has made a motion to republish those 911 tapes. And so I have granted the motion, and they're going to do that at this time.
Yes, Your Honor.
Yes.
For the record, we will be publishing States Exhibits 3, for Terry Robinson's 911 calls, States Exhibit 4, the defendant's 911 calls, and States Exhibit 6, Tiana McCrae's 911 call.
Okay, thank you. Is there an objection?
I would raise the objection we had at the bench, but understanding this.
Right, so the court has ruled and has allowed the state to republish.
The first 911 call that we will publish will be Terry Robinson's calls.
Hey, we have an accident up here by Clarktown and Forest Parkway. Clarktown and Forest Parkway. It's a truck. Unfortunately, hit a vehicle, and I'm looking at the guy now. He's pretty good. He's moving and everything. But we had a truck that's had an incident with a vehicle. Clarktown and Forest Parkway.
What kind of truck is it?
It's a semi-tractor trailer, and it's a pickup truck.
A red Dakota?
Yes, red Dakota.
Okay, does it say that you want to try to insert?
But you need assistance? You need an ambulance? Sir. Yes, sir, it's okay. You need an ambulance, sir? He's not saying anything. So you okay? Yeah.
Okay, if he's saying that he needs assistance, he needs an ambulance, then no.
All right. Sir, do you need assistance? You need an ambulance, okay? Well, I mean, you with this, well, are you okay?
We have police in around, but it's
Yes, I'm aware. I'm a state officer. I work at a GDC. So, yeah, that's 540.
is any airbags
She was
deployed?
there. She was there. Nah, she met.
I'm sorry.
No, man, I'm talking to the gentleman who's at the trailer truck.
Mm-hmm.
And he was, the car was working in. You know, they know what happened. He fell asleep. But you need to be into that. Don't start it. Don't start it because you're smoking. Sir, just start. Right there, right there.
Are they obstructing the roadway?
I saw from the I saw it coming out. I saw the car coming. So they just got. And then I see the light was green. Yes. You had it, you had it.
Okay, sir.
Yes.
I was going to be out there, okay?
Yes, ma'am. We'll apologize for that, ma'am.
No, that's okay. Thank you.
Okay.
Clinton County 911, what is the location of your emergency?
Clark Howell and Forest Parkway. We had a call earlier, and it's been over like 20 minutes now, and no police or no ambulance have shown up at this location. And like I said, it's a ball, a red Dakota, and a semi-tractor truck, and none has showed up at this moment in time.
Okay, I just hit a call. We already have someone on the way.
The reason why I'm asking that because the driver who caused the accident, I think he's impaired. Something's going on with him. And so the thing about we're trying to tell him to turn his vehicle off from the smoke, and he's not following the command. So that's why I'm asking to see what if he's moving his ears. He's going to drive off, man. He's driving off. He's driving off. Take a picture of the driver light. Take a picture quick. He's driving off. He's driving off.
Where's he going towards?
Yeah, he's heading towards Riverdale Road. Upper Riverdale Road. That's where he's headed.
What kind of vehicle is it? Is
He's
that
in
the
the
red
red
Dakota?
Dakota. Get out the road, sir. Get out the road. Hurry up.
What's the tag number?
Red Dakota, front end damage to his red Dakota. Did you get a picture of the driver light? That's tag. Oh man, let's get out the road. Get out the road. He's headed towards Riverdale Road, heading towards 285 area. Riverdale Road. He's heading west on Forest Parkway towards the area.
Give me one
Okay, good. Go. He's gone. Now the other driver who was and she's going to take a picture of the vehicle. Yeah, he's fled. He's an African American. Two vehicles. His vehicle and the truck. The truck is still here. The driver of the truck is still here. And so, sir, step out the road. Just step out the road, please. So he's in a red Dakota. It's a 96 model, give or take 97 model. He's an older black gentleman, gray hair, blue shirt on, and front end damage. Heavily front end damage in front. Heavily front end. I knew he was going to do something. If I was in uniform, I would have picked a see, but I didn't. So,
Okay. So
he's heading toward that area. If we can get policeman up that way, I know traffic. I knew there's an incident up that way. Hopefully, that there's another officers on that see him.
give me 1 moment.
I know it's RHA 5933. There it was. RHA 5933. RHA 5933.
I got it. Robert Henry Adams 5933.
Yes. It's okay. She got it. It's all good. Yeah. Hopefully the lady in the Jeep was almost in the incident, so she turned around and she went after him. So she's going to take a picture of his vehicle and stuff. Can't you believe it? I knew he was something wrong with it, guy. I knew it. God. This is crazy. Yeah. Well, you're not going to get far. This truck is going to overheat. This truck is going to overheat. Okay, ma'am, you have my number. If anything, y'all can hit me back. But I'm here with the driver of the truck, the semi-truck, and everything. So my number, you have it.
Okay.
Thank you,
right.
ma'am.
Thank you.
All right.
The state will now republish the defendant's 911 calls, which were state's exhibits 4.
Payne County 911, what is the location of your emergency?
Yes, ma'am. I'm actually on Forest Parkway and Clark Howell Highway. and there was just an accident. I'm sure they've already called, but I just witnessed it, and I just wanted to make sure that I guess called the police as well in case they didn't.
All right. Were they on? What were the kind of vehicles involved?
It's a red Dodge pickup truck. I think it's a Dakota, and a semi was involved. And the red Dakota ran the red light and slammed into the side of the semi.
It doesn't look like we received any reports on it yet. I'll go ahead and put in a call here.
Okay.
Red Dakota. And were they on Forest Parkway or on Clark Howell?
The semi and I were turning left onto Forest Parkway, and the Dakota was going west on Forest Parkway.
Oh, okay. And what's your name?
My name is Hannah, Hannah. Last name is Payne, Payne.
And what's your callback number?
470-512-1847.
We appreciate you calling this in. We'll get someone out there and try to assist them.
Okay, thank you.
Thank you. Bye-bye.
Payne County 911, what's the location of your emergency?
Yes, ma'am. I'm on Clark Howell and Forest Parkway, the intersection. I actually called about 20 minutes ago for an accident, and no one has shown up yet. But I am under the impression that the guy that caused the accident, who ran the red light, is drunk, and he's gotten back in his car, and he's looking like he's trying to drive away.
Okay, can you get his tag number?
Hold on. He's driving away. It's a red Dodge Dakota.
Mm-hmm.
One second. Hold on. Okay, so he is going west, down down Forest Parkway.
Okay, so you couldn't get a tag number?
No, but I'm catching up to him right now.
Okay, ma'am, we actually do not want you to chase him. We just want you to be safe. And it's
I
not
understand.
to chase him.
I understand 100%. I'm just going to get the tag number, if nothing else. But I am going west down Forest Parkway. And we are almost up to him. I mean, his radiator is busted and everything. So I honestly have no idea how he's driving the truck the way that it is. Okay. It is a Georgia tag. License plate is RHA as in apple, 4859.
Okay. So if you can go back to that location where the incident happened, it's because someone is actually on the way to you guys now.
Okay, well, there's a police officer there, but he is drunk. I'm sorry, but I'm here to tell you I'm not going to follow him. Because he is going to cause another accident. So I will stay behind him until an officer can get to us. But until then, I'm not moving.
Yeah, no, that's what I want. I want you guys to go back to the location where it happened, and an officer will be out there momentarily, okay? Ma'am. Ma'am. You were not supposed to follow him.
He hit my car.
Okay, you got the tag number.
There's a police officer down the street. Tell them to come up here now. He pulled the trigger on my gun after he attacked me. Tell the police officers to turn around from the 285 entrance and come up here immediately. And now he needs paramedics. I'm safe, but he ain't. Can you say? You say what happened?
Okay, ma'am, where are you guys located now? Ma'am.
I don't know. I did. No, I don't.
Okay, ma'am.
There's a police officer here now.
Okay, speak with them.
All right.
The state will now republish State's Exhibit 6, which is Tiana McCraney's 911 call.
Clayton County 911 was
It's a cop.
Hey, call type for the transfer. Hold on, sweetheart. Call it about Forest Parkway and Riverdale Road.
Yes, she shot him.
Okay.
She
Hello?
shot him.
Hello?
Hi. I'm sorry. I'm on the intersection of Phoenix Boulevard and Riverdale, right before the highway. Is this woman?
Okay.
So, sorry, they got it was like a merging lane, and then it was a merging lane, and then she like got impatient and went around him for no reason because it was coming traffic, and then he almost hit her because he did that, so he braked suddenly, but then she got mad and hopped out her car, and then she pulled out her gun and started screaming at him, and he was like, "What the heck?" And then she was like, "I will shoot you," and she started hitting him. Yes.
Okay, now where are you guys?
We're right by the exit of 285 West and 285 North, and it's like Phoenix Boulevard goes one way.
Okay, yeah, I have somebody on the line for that. Okay, ma'am.
Okay, thank you. Hello?
Yes, ma'am. Are you still there?
Sorry, yes, I'm still here.
Okay, you said she pulled out a gun.
Yes.
Did she shoot the gun?
We heard a gunshot, and then one guy got out his car, and he was like, "Yo, we need an ambulance." Now I'm blocked in. The guy was like, "We need an ambulance." I don't know if she shot him or not. Sorry, dude. And now, did she shot him? She shot him. What?
What type of vehicle were they in?
She's getting locked up. He was in like a. Hold on, let me get out. It was like a brown called Dakota.
Okay.
And she's a dude.
Okay, we have someone in with us, okay?
They're there already. But okay.
Thank you.
All right, thank you.
That is all we have, Your Honor.
Okay. Thank you. Does the state have any other witnesses that it intends to call?
No, Your Honor, the state rests.
Okay. Okay, so the state has rested, meaning that all the evidence that they intend to adduce in this case has been presented to you at this time. And so there are things that I need to take up with defense counsel and the state at this time. And so I'm going to excuse you at this time. I think it's an appropriate time to take a lunch break. It is now approximately 11:40. I'm going to give an extended lunch because there are things that the court has to do with both the state and defense attorney at this time. And so I'm going to instruct you to be back at 1:45 this afternoon. So you're excused. Have a good lunch.
I request Louder to get composed. She's over here. Haven't heard that. She may take a brief 3-4 minute break.
And we can, Attorney Tucker, but I think that any motion you're going to make, you would probably just make now and then we'll take a break. Yes. Because I don't expect that your motion will be extended.
Yes, ma'am. You join me in the motion?
Yes.
At this time, Your Honor, I would make a motion for directed verdict based on the facts that have been presented here, based on the evidence that we've heard so far. I would, and I'll go through each charge one at a time and make my argument. That's okay with the court.
Okay.
At this time, Your Honor, I would make a motion for directed verdict that the state has not carried the heavy burden of proving beyond a reasonable doubt of the offense malice murder, as they've stated in their allegation, that Hannah Payne did on May 7, 2019, with malice aforethought, caused the death of Kenneth Herring, a human being, by shooting him with a firearm. The evidence we've heard are contradicting testimony of what's going on. We've heard one witness say that she came out and held him at gunpoint. We had one witness come out and say she jumped in the window. We had one witness come out and say the accident happened somewhere else besides where the other two. They said that disputed testimony. Some say the gun was holstered until the car hit her car. Some say she came out with it pulled. We heard testimony from the forensic examiner who said the angle of the bullet in the entrance was a slight right to left, which the theory that was shot outside the vehicle, and we saw the video, that is not a correct account of what happened. In the video, we heard testimony saying that they were fighting over the gun, going back and forth. And then upon the gun going off, immediately she picks up the phone and requests assistance from the police and an ambulance. She's not a nurse, she's not a doctor, but she does the best thing she could. She explains to 911 what happened and requests assistance for him, for Mr. Herring. So in no way or form has anybody come in and proven there was malice of any. There was no malice, no testimony of her saying, you know what, today this guy caused an accident, I'm going to take his life. There's no testimony, there's no evidence that even gives an inclination that that is what was going on. And even though you have people say, oh, she had no remorse or whatnot, she was still on the phone attempting to get an ambulance to come there. She stood and she argued or explained to the bystanders she didn't have her finger on the trigger. This was not anything that had intent. This was a situation where she got grabbed, she was being pulled, and she pulled the gun to defend, and then he grabbed it, and the gun went off. And from her, on the 911s, her statements on the 911s, that he went off based on him grabbing the gun and his finger pulling the trigger. There's no malice that has been established in any form or fashion to constitute or even prove anywhere near a reasonable doubt that she did do malice murder. And should the court see and review the testimony the way I have, then that would basically take out the malice murder and the gun charge that was with it, count 6. Then I move to count 2, felony murder, where it says that on the 7th of May 2019, while in the commission of aggravated assault as alleged, a felony that caused the death of Kenneth Herring, a human being, the testimony was that, once again disputed, you don't know if the gun was on her hip or the gun was pulled or what to believe, but based on the video and the testimony from Mr. Williams, who had the video kind of corroborated exactly what he said, that the gun was never pulled until after the struggle was ensuing, and that the individual other accounts were that the vehicle had stopped and not hit her vehicle, but then did accelerate and hit her vehicle. And no one was able to give an account of the position of her, whether she was on the side of the car, whether she was on front of the car. We did hear somebody say it was like an inch, but anybody who would say it was like an inch would have said the car's hit. So I'm not sure how we can use the weight of that testimony because it doesn't appear to be possible or logical. The gun was not pulled until after she is screaming stop. They're going back and forth the struggle. You saw pictures of her shirt ripped. You saw the pictures of the scratches all on her neck, her arms. You saw the swollen wrist. All of these show that there was a struggle ensued. And the testimony, they said that she was hitting him or punching him. There were no bruises. From the forensic examiner, she said there were no bruises or contusions or anything on his body except for a pin-size bruise on his left shoulder where the seatbelt would go. But it was not the size of a seatbelt, but a pin-top size. Therefore, to pull the gun, she had to use for self-defense as he was continuously grabbing, pulling, and revving up his car and driving. And in the 911 tape, at one point she starts screaming, you hear the revving of the vehicle, which confirmed that the revving of the vehicle was to drive off or to hit, or I'm not sure what his intentions were, but from a reasonable person's view who comes out with a phone to say, here, I have the police on the phone, it's not reasonable for somebody to rev up the engine or grab her or try to ram her or her vehicle. She stated in the 911 call, he just hit my car. And luckily it was her car and not her. So as for the aggravated assault, upon him grabbing and suing, you saw pictures that were in the truck. A lot of people didn't hear what was being said from inside the truck, But there was a lot of instruments in there that could have been used for serious, immediate bodily harm. There was a knife. There was a small saw. There were needles all over the place. All of these could have been used to cause immediate harm to my client, and she was only able to pull a gun to try to deter him from continuing with the actions he was doing. And she stated she never had her finger in the trigger. Therefore, it was never an intent to pull a gun and shoot. It was for protection and to deter him from his actions there. And therefore, because the aggravated assault has not been proven beyond a reasonable doubt, the felony murder in count 2 should not survive the directed verdict based on the facts that it has not given rise beyond a reasonable doubt that the aggravated assault occurred in the manner it was accused to make an assault upon the person of Kenneth Herring. It was pulled as protection and to deter him from continuing his actions that he had continuously did, even though you heard her screaming, "Stop, stop, stop." And therefore, if the court sees it, and I presume they will, sees count 2 and count 3 would be resolved with the directed verdict, and that would take out the count 7 of the commission of the possession of a firearm during the commission of a felony. And I would bring the court's attention to count 4, where they said the felony murder with the underlining felony being false imprisonment. The state has put testimony up there that said the car was going, she pulled in, you saw the angle. 2 of them said that it stopped in front of him, that he had space. One says like an inch, one says not sure how much the space is, one didn't really have an angle to see it. But they all confirm that there was not a collision, that the car was there. And as we saw from the pictures that were tendered, there was plenty of room to move or to go to one side or the other. The guy that was filming it was driving right there beside it. Should Mr. Herring have wanted to move or not participate in what was going on, he could have easily driven out, backed up, after hitting the car, backed up and drove off. And once again, the presumption is that he had the ability to do that, and it was not that the car stopped him from doing that, that his truck was leaking radiator fluid, that the truck was badly damaged. And you heard the testimony from the state officer saying this car ain't going far. It's smoking and it's leaking fluid. That engine's going to stop soon enough. We haven't heard any testimony from the state to say that the vehicle was operational, that after the event when they came to get the vehicle, that it was able to drive. So him being in that position was at his own actions. He drove forward and hit the vehicle. Now, could he have driven off? From the testimony, from the views and the pictures, it appears so. But if the vehicle was not properly running at that time, based on the damage, based on the loss of radiator fluid, based on a lot of factors, that is why he was there. Not because of a car pulling in front of him. With that being said, he had the door locked, or it appeared the door was locked, so nobody could get into the vehicle. That is another reason that he was not able to get out, because he had his window down and the door appeared to be locked or damaged, so it was unable to be opened. All of these do not give rise to beyond a reasonable doubt. There are many theories that can be brought out there, but evidence has not been presented to confirm one way or the other. Evidence wasn't even presented to talk about the vehicle and was it operational after he accelerated and hit Miss Payne's car. So to try to categorize Miss Payne as the proximate cause of why he was there in the state he was, or why the vehicle was unable to move, or why he was unable to move, is not at the hands of Miss Payne. It's the hands of him and that vehicle and his actions. He had reasonable means of escape. He could have just backed up and pulled off. He didn't have to ram her car. He didn't have to accelerate forward. You saw the video driving down right to the left, and that car kept moving. Did not appear to be, any kind of traffic or anything impeding him from driving slowly by and watching it. As you look to the right side in one of the pictures, he didn't even have to go on the sidewalk. He could have scooted around her without even going on the sidewalk. No one said there was something on the sidewalk that was stopping him or impeding him from going that angle and moving on. So to say that she caused false imprisonment or is the cause of that has not been proven beyond a reasonable doubt, not through the evidence that we've heard so far. And because they have not proven that felony, it would not give rise to felony murder because the underlying felony of false imprisonment has not been proven. There's numerous theories out there. There's numerous things that occurred that were not even touched or addressed. And therefore, because the false imprisonment was not done by Ms. Payne, then count 4 should fail because it does not give rise to the felony that would justify the felony murder, which would take out count 8, the possession of the firearm during the commission of a felony. Therefore, based on all the evidence we've heard so far, the testimonies and the lack of testimony to explain, the state has not carried their burden beyond a reasonable doubt to prove any of these 8 cases. And I respectfully request this court to grant my directed verdict motion. Thank you.
The state's response.
Judge, as you're aware, the standard is whether or not there is sufficient evidence for a jury to decide the case and the charges, and you have to view the light and the evidence in the light most favorable to the state. As it relates to malice and malice murder, as the jury charges that we have provided and that defense has provided, malice is not ill will or hatred. It is basically the intent to kill, and it can be formed in a moment. And I think that the evidence that has been provided regarding this defendant's demeanor and her conduct, including her own words on the 911 call, where she is cursing, screaming, telling the victim, "I will shoot you," which is basically her stating her specific intent to kill. And all of the witnesses who indicated that she was striking the victim. And then her own statement, basically, when she tells us all why she killed him, because he hit her car. And so the state has provided sufficient evidence for the jury to consider malice murder in this particular case based on all of the facts and circumstances that have been provided. As it relates to felony murder, aggravated assault, the uncontroverted evidence is that the defendant had a firearm, which is a deadly weapon per se, and that the victim, as testified to by the witnesses, was placed in a reasonable apprehension of receiving a violent injury. All of the witnesses indicated he looked shocked and confused, and that would be consistent with someone who is placed in a reasonable apprehension of receiving a bodily injury. Therefore, felony murder based on aggravated assault and the aggravated assault have been met. As it relates to the false imprisonment, the only thing that is required for the state to prove is that the defendant, as noted in the indictment, detained the victim without lawful authority. There is absolutely no evidence that she had any lawful authority to do any of this. And all of the witnesses described that the victim was cornered, that she trapped him, that she maneuvered to block him. The fact that he could have tried to figure out a way to back around all the cars and drive on the sidewalk does not does not negate the fact that he was detained by this defendant. The photographs, most of them, depict circumstances that existed once all of the cars were removed. That was the evidence from the witnesses in this case, certainly from Sergeant Ritchie, who indicated that those photographs were taken much later. So the traffic circumstances are more reflected in the video, and the fact that their vehicles are touching. Her wheels are clearly turned in order to block him in order to detain him in all of the photographs. He has nowhere to go. So he is detained as intended by the statute for false imprisonment, and therefore the false imprisonment and the felony murder associated with that, there is sufficient evidence for those to go to the jury. And in fact, Judge, all of the evidence is she's standing, even though she's telling him to get out of the car, she's basically standing there. She's right at his driver's side door, and she's holding a gun to him. So his choices are try to drive back up or try to get around her car even though it's blocking him in, or drive another way when there's a gun there. So he is very clearly detained, and we would ask that you deny the directed verdict on that as well, and as it relates to all of the gun charges that support that. I think the only other indication is a conversation about who pulled the trigger, and Judge, the state tendered I believe it's State's Exhibit number 22, if I may retrieve it.
Yes.
Which reflects her finger on the trigger very clearly. Even aside from that, the state's contention is that once the defendant is the aggressor, which is exactly how she has been described, what's in the victim's vehicle, his conduct, how he drove toward her vehicle, which again, you saw photos of the damage, a term that I use loosely, based on smudges, 2 smudges on her tire and her, I guess that's the wheel wall fender. There is no evidence that this victim made any attempt to ram her or run her over. The indication is, as from all of the witnesses were asked, her demeanor, aggressive, very aggressive. Once she is noted as the initial aggressor, as the aggressor on scene, nothing that Mr. Herring did is relevant. She could talk about it, but it's really not relevant to her defense, because she is no longer eligible to claim self-defense once she is the aggressor. And that is in the jury charge, the pattern jury charge, that the initial aggressor cannot claim self-defense and cannot use self-defense. So we believe that the evidence in this case is more than sufficient to allow the jury to deliberate and to reach a verdict on each and every charge listed in the indictment.
So the court, having heard arguments from defense counsel as well as from the state, has determined that there is sufficient evidence for the case to be released to the jury and for them to deliberate and decide the case. The jury can view the evidence in the light most favorable to the state, and so the case will be released to the jury on all the counts 1, 2, 3, 4, 5, 6, 7, and 8.
If you clarify, you just said the evidence would be released to the jury and most favorable to the state. Is that your decision, or?
My decision is to deny the motion for a directed verdict, And because the court has determined that there's sufficient evidence for the case to be released to the jury to be deliberated upon and for them to decide the case on all the counts 1 through 8.
But there still is a presumption of innocence that goes with my client when it's released to the jurors, correct?
I have said nothing that would indicate anything different, Attorney Tucker.
Maybe misheard. I thought I'd heard that.
Okay. All right. So before we broke on Friday evening, I did talk to Miss Payne directly about whether or not she was going to decide to testify or not to testify, and sort of gave the weekend for consideration. Has the defendant made a decision?
Your Honor, we're right there. I believe if we could break for lunch, we can come back for lunch, we could stay. I did have other witnesses that I have subpoenaed. I want to make sure that they are here. And based on that, I can make the definite decision whether she will testify or not. But if we just have lunch to go over what we've heard today and what we've discussed, we'll be ready to make that announcement afterward.
Okay. Thank you, Attorney Tucker. Anything further from the state?
Nothing from the state.
Okay. All right. So it's 12. I did instruct the jury to be back by 1:45. The court has to go through the jury charges. But it is my understanding that the defense will be adducing evidence.
I've got to make sure that my witnesses are present and that I speak with my client, but our intent is to have something brought out. I just want to make sure the witnesses are here or available, and then I will discuss with my client.
Okay. All right. So at some point, I do want to review the jury charges, so I will do that after your decision whether you're going to present evidence or not. And if you are, allow you to do that, and then we can release the jurors and do our jury charges.
Thank you, Your Honor.
Okay. All right. So court stands adjourned until 1:45 p.m. Thank you, Deputy Diaz. Good afternoon, everyone. Okay, I'm going to step back off the bench for a couple minutes to allow one of our jurors to actually get back here. As soon as that person does, I will come back on the bench. Before we broke this afternoon for lunch, Counsel for Defense had indicated that he would make a decision whether he was going to present any evidence. On Friday as well, I had given the defendant certain instructions as to whether or not she intended to testify. And so the court would like to determine whether a decision has been made.
Your Honor, when I went back to my office, I started calling the individuals I had subpoenaed. And one of the individuals was Tim White, which I think the court's ruling kind of did away with anything I could get from him. So I didn't further the conversations with him. The other witness was Bill Yoder, who took the photos and could come in there and testify to the photos he took, and possibly as an independent contractor saying why he took them. But I don't think that would hold the weight of having the investigator or everything else that we brought in. I think his testimony would just be delaying or furthering the case without having the substance that is necessary that would not waste this court time or be judicially efficient. I have discussed with my client the pluses and minuses of testifying. I've gone over all the evidence and the witnesses that we've talked about, and I've heard two different approaches. She got very emotional, as you can see right now, and it is an emotional roller coaster ride she's been on. I mean, for 4 years she's had this, gotten ready a couple of times, and her decision, she will testify, so I will present. But if we could have a moment for her to collect herself, based on our conversations, they were kind of clear cut and kind of harsh, but the reality is this is something she had to make a decision, tough decision, and she's made it. And if we just give her a minute to collect herself before bringing in the jury.
I will give her an opportunity to compose herself. I am going to direct the questions again so that the defendant, Ms. Payne, will actually put on the record that this is what she wants to do. I understand you indicating that, but she has to put on the record what she wants to do.
And I appreciate that, Your Honor.
Are you ready?
Your Honor, she said she will testify, but there will be, of course, a couple of motions we would want to approach to talk about prior to any testimony.
Okay, so let me put again on the record so that Ms. Payne can personally respond to the questions. Ms. Payne, do you understand that you have a right to testify? And if you want to testify, then no one can prevent you from doing so?
Yes, ma'am.
Do you understand that no one can make or compel you to testify?
Yes, ma'am.
Do you understand that not your lawyer, but you personally are the one who decides whether you will testify or not?
Yes, ma'am.
Do you understand if you do not testify, then upon proper request by you, the court will instruct the jury that your decision cannot be used against you?
Yes, ma'am.
Do you understand if you choose to testify, you will be both examined by your counsel and cross-examined by the assistant district attorney?
Yes, ma'am.
Do you feel that you need any additional time to think about whether you want to testify or not?
I'm sorry, did you ask if I felt like I needed more time?
I did. But understand that I gave you on Friday all of the weekend to determine. Your attorney has indicated that you intend to testify, and I just need on the record that you will personally place on the record that you want to testify or not. So, do you personally want to testify or not?
Yes, ma'am.
Yes, meaning?
I want to testify.
Okay. All right. Attorney Tucker, what motions do you need to make at this time?
I believe from her testimony, we will be wanting to present a video. I believe also a video was stopped with a portion that we would want to be able to have the rest of that portion come in. Based on now that she's testifying, it won't be self-serving statements. It will be statements that were given at the scene. And I believe that the state will want to introduce the video, the transcripts from the interview that occurred at the police station the night of, that there was an agreement not to bring in the written portion of it. But it's kind of, if you show part of the video, I think, once again, it's cutting short, and I know why certain parts of that video should not come in, and I know we had an agreement.
Okay.
I would just like to.
So, can you stop at that point, Attorney Tucker, and counsel's approach? I'm going to allow the state to go ahead at this time and place on the record particular times with respect to the video that is proposed to be shown.
Judge, it's my understanding, if the defendant is choosing to testify, there are two statements that are recorded of the defendants. The first one, she is detained in the back of a patrol vehicle, still on the scene. Sergeant Marion approaches and asks if she will talk to him, and then they have a conversation about what occurred. And that is located on Sergeant Marion's body cam from minute 1740 through 2303. We would, it was not our intention to play anything in additional on Sergeant Marion's body cam because he's talking to other witnesses. If the defense wants those things in, I'll leave that to them. But that's the only part that contains a statement of the defendant. The defendant is then taken to the Clayton County Police Department, where she is Mirandized and provides a Miranda waiver, and then conducts an interview with Detective Hayward, who is here to testify in rebuttal if necessary, and Detective Moore. We were intending to start that interview at 7:37:56 because no one has come in the room yet. It's completely dark and empty. And then the defendant is sitting in the room by herself for quite some time. There's a gap there as well from 7:37:56 to 7:53:40. And the state would move that forward, but again, because she's just sitting there. However, the state is requesting to play 7:53:40 through 8:01:00 because the defendant is in the room removing her long fingernails, and that is recorded. After that occurs, from 8:01:00 until 8:48:30, the defendant is alone in the interview room. She moves around, she walks around, she lays her head on the table, she changes position several times, but there is nothing of evidentiary value in the defendant sitting alone in a room for 47 minutes and 30 seconds. So the state was not going to play, and we could put on the record in front of the jury that the defendant is alone and not being questioned during that time frame, so that there is no curiosity about why we're forwarding. So the state was going to forward that. There is a section where the detective begins to talk to the defendant about writing a statement, which the parties have agreed that for varying legal reasons it is not admissible. So we would redact or just move the cursor forward, and that would take out minute 9:34:00 through 9:35:20. And then we would play from 9:35:20 to 9:36:15, because that is when the detective has asked the defendant about potential injuries and she begins to point things out. So rather than stop when they first talking about writing a statement, I didn't think that was appropriate, because there is something that's beneficial, or at least in their opinion, beneficial to the defendant. So play that and then stop at 9:36:15 when the detectives are getting up to go get the paper for the defendant to write. I don't know if I need to place on the record the reasons that we're stopping. I think we've talked about it a little bit. But at some point, defense counsel enters the room while the defendant spends some time just sitting there writing. Defense counsel enters the room, and so there are some comments that he makes to her that we believe would inflame the jury, and they are inappropriate to play because he actually makes a comment about what he believes about what she's written.
Your Honor, this is attorney-client privilege, what she's disclosing here, and I don't think it's appropriate to disclose it to the court or to the open court.
Okay, so there was an agreement that certain portions would not be played, and
we've had this
that was
conversation
determined.
Yeah.
So we can stop there.
But there's reasons that it's stopping based on that. I mean, he's being recorded, so it's not attorney-client privilege. He acknowledges he's being recorded, so it's not a private conversation. However, that is the reason that we're stopping it, is because defense counsel enters and there's conversations. And so we just believe the safest route, and counsel agreed with that, is to stop it at 9:36:15.
Okay. And is that your understanding, attorney?
It is, Your Honor, and
Okay.
we just want to emphasize that 47 minutes, that it is stated why they're speaking for, because she's in there alone and there's nothing being done.
Right, that's fine, and that will be explained to the jurors.
And if it makes counsel feel better that there are, you can just say there are sections that where nothing's being said, that we're going to forward through, and that they should not speculate or consider what's not played. If that's up to him. Who wants to charge?
Yes, Attorney Tucker can be allowed to say that to the jurors to explain. Okay. Are we ready at this point?
I just got to grab my pad real quick. have some questions.
Okay, I'm going to go ahead and bring the jurors back in at this time. Bailiff Ennis, if you would, thank you. Good afternoon, ladies and gentlemen of the jury. At the time that we broke for lunch, the state had rested, meaning it had concluded bringing all the evidence it intended to adduce in this case. At this time, I'm going to inquire of the defense if they intend to call any witnesses. Attorney Tucker?
Yes, ma'am. I do plan to call Ms. Payne to the stand.
Okay, you may. I can. Ms. Payne, please raise your right hand. Do you solemnly swear or affirm any testimony you shall give in this case today shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, you may. Lower your right hand, have a seat. If you just put yourself up to the mic and project so that we can all hear you and that the court reporter can record what is being said. You may proceed, Attorney Tucker.
If you could say your full name for the record and spell it out for the court's knowledge.
It's Hannah, Hannah, Payne, Payne.
Okay, and Ms. Payne, have you lived in Bay County or Clayton County for close proximity? I don't want to get out of addresses, but have you lived there the majority of your life?
I have. I was born and raised in Clayton County and then moved to Fayette when I was 8.
Do you have any family members that are law enforcement? Do you
not.
recall? What do you do for a living?
I'm in property management for apartment communities, and I've been in that industry now for going on 10 years.
Okay, so you came straight out of high school into that.
I did.
And that kind of industry, what do you do for your job?
Typically, I'm in the field. I go from property to property, either collecting rent, sometimes walking vacant and or abandoned apartments that could potentially be under construction, and I would show vacant apartments to potential renters.
Okay. So at times you were carrying basically tills for your company of large amount of money?
Correct, yes.
Okay. And you testified that on some occasions or more occasions you have to show empty properties or empty locations to people that you don't know or that you're told to by your company?
Correct.
Okay.
Whether it be vacant apartments or vendors, either or.
And how do you feel about that?
I mean, it's a part of my job. In the beginning, we had smaller properties where I was the only person who was going from property to property. There were occasions that were unsettling, but it was still a part of my job. And the longer that I was with the company, the larger we got, the more properties we received, and the more, I guess, it put me more out alone by myself, without additional site staff, without anybody with me.
And they would know that you were going to these sites, correct?
Correct. Not exactly which ones. I would be kind of all over the place, depending on which ones I was going to.
And because you were going to all these different places to meet people you don't know, did you do anything for your safety?
I did.
And what was that?
I registered for a concealed carry permit, and when I received it, I purchased a firearm.
Did your company know about this?
They did, yes.
And were they in support of this?
Yes, they were.
And it was not unusual for other individuals with the same type of work to wear a gun or have a gun?
No, not at all.
Okay. And you said you purchased a gun. What kind of gun did you purchase?
It was a Springfield, and it was a XD because it was smaller, so I was able to keep it concealed.
Okay. And you got a valid permit, correct?
Correct.
What else did you do to help make sure that carrying a permit or carrying a gun on your side would be safe?
I would go to the shooting range, and at different shooting ranges they offer kind of like a variety of options, including self-defense kind of classes, or tutorials rather.
And did you ever take one of those classes or tutorials?
I did.
And which one did you take?
It was a while ago, so I wouldn't be able to tell you exactly, but it was a self-defense training course.
Okay. And in this training, what did you learn from what they were teaching?
Just how to properly store your weapon, how to properly remove your weapon, how to make sure that your safety when doing so doesn't cause accidental discharge. And they would explain how when you pull your weapon out, that the way you hold it is determined based on what you're ready to do. In other words, you keep your index finger on the slide until you're ready to pull the trigger. When you're ready to pull the trigger is when you put your finger into the trigger guard.
Right, now when you say the slide, is that the top portion, the side portion, or is it a combination of both?
Like the side.
Okay.
How your hand would just rest.
And is that all that they were training for at that time?
For the most part, yes.
Okay.
I mean, they taught us, you know, how to load or unload and smaller things like that, but
Have you ever had a accidental discharge of the firearm while loading or unloading?
no.
Okay. And did you commonly wear this weapon?
Every day.
Where'd you wear it?
On my person, you mean?
Mm-hmm.
I had a holster that went inside of my pants, and I wore it on my front right hip.
Was that visible to individuals?
No,
Okay. And did you do that purposely?
I did.
Okay. And do you recall May 7th of 2019?
I do.
Prior to that day, have you ever had to draw your weapon or find yourself in a position where you would need to?
No.
Okay. So on this May 7th, of course, you've been hearing these stories. Could you tell us what happened on that day?
I can. I was on my way home from work, and I was coming up to an intersection where the light had just turned green. As I was getting ready to turn left, there was a semi that was turning right. Someone ran the red light, and I watched him run right into the tractor trailer.
Okay.
I pulled off to the side, and I got on the phone with 911 just to give an account of what I had noticed. I had assumed that the truck driver or someone else that was involved had already called, and they hadn't.
And if I could stop you right there. You said that you pulled off to the side. Whereabouts?
I pulled up onto the curb,
Okay.
right through the intersection.
And why did you do that?
I wanted to get out of the lane of travel.
Okay, so there was heavy traffic that day.
It was pretty steady.
Okay. And is that where you called the 911?
It is, yes.
Okay, and then what did you do?
After I got on the phone with 911, I was kind of explaining everything that I saw, and I started to walk over to the truck driver because I noticed that there was someone else who had witnessed it, who pulled off to the side.
And if, I'm sorry to interrupt. You said you walked up to the truck driver. What was that driver's name?
I believe it was Mr. Kimball.
Okay. All right, go ahead.
So I walked over to the truck driver, and we kind of just were conversing, asking, I don't even know what happened, and he just was confirming that we did have a green light. So I noticed that someone else had walked over to the other vehicle that was involved and was checking on them. After talking to Mr. Kimball for a while, he was on the phone with his dispatch the entire time, and so I was kind of relaying everything that happened so that they were able to hear it from me and not just from him.
Relaying it to whom?
To his job.
Okay.
So his supervisor, I would assume.
All right, so you're speaking with him, relaying to the dispatch about what was going on, confirming the light was green for him.
Correct.
And then what else happened?
After that, we were kind of just standing there waiting for the police to arrive, and the other gentleman who had witnessed it walked over to us, and he introduced himself and said that he was a state officer, and he flashed his badge and said that he had checked on the other gentleman and that was asking us, are we okay? Is everybody all right? And actually told me that he had saw where he ran the red light and confirmed it to Mr. Kimball as well.
Okay. Now, Clara, he came and identified himself as a state officer?
Correct.
Okay. And you've heard a couple of times it being called a correctional officer or another name. Are you sure he identified himself as a state officer to you and to Mr. Kimball?
Correct. He told me that he was a state officer. I didn't find out that it was a correctional officer until months later when I found out from you.
But he did show a badge?
He did. Mm-hmm.
Okay.
I mean, he didn't pull it off. He just lifted his shirt, and we saw the badge, and then he continued.
And how was he speaking to you, or how was his demeanor to you and Mr. Kimball?
He was trying to make sure everyone was okay. making sure that we kind of stayed over here, and that anything that, you know, we could remember that happened, we were kind of going over it with him. But he seemed to be comfortable with the situation and making sure that all of us felt comfortable, I guess is the best way to explain it.
Okay. So your voice on the 911 appeared to be kind of calm, and so that was the tone, or how you perceived everybody's tone as this was continuing on?
For the most part, I think that me and the truck driver were kind of more calm. The officer, the way that it was kind of like he was, I don't know any other term other than kind of hyped up. Like he wanted to make sure that he was in charge in a way.
Okay. And what else did he state while you were sitting there waiting on the police to arrive?
Well, me and the truck driver were curious because we didn't know what had just happened. It seemed obvious that he ran the red light. So we were asking him if he was okay and if there was something going on. And he said he's okay, but he said he's definitely inebriated.
Are you sure that's the word he used?
I'm positive, because it prompted both me and the truck driver to reply simultaneously saying, "Do you mean he's drunk?"
Okay. And did Mr. Kimball's dispatch hear or overhear that conversation or hear the conclusion?
I'm not sure, to be honest.
Okay. So the state officer said that, and it kind of sparked yours and Mr. Kimball's attention. What happened next?
Afterwards, we're still standing around, probably another maybe 10 or 15 minutes now, additional from the original 10 minutes or so. And me and Mr. Kimball are continuing to speak, and the state officer had walked back over, because at this time the guy in the truck had got out of his vehicle.
Okay. And when he got out of his vehicle, did the state officer address him?
He did.
And what was said?
He was just asking him what was he doing, and where are you going? You know, to come out of traffic, because his truck was still in the lane, so there were still cars that were passing, and he was just basically trying to make sure you need to just come out the way and stay out of traffic.
So from your perception, the state officer was remaining calm, trying to direct. At that time you didn't know, but now you do know, Mr. Herring, to be safe and get out of harm's way, correct?
Originally, yes.
Okay. And then what continued from there?
I couldn't hear what they were saying, but he kind of started walking around, and the officers started following him around the vehicle, and you could see him having conversations, but again, I couldn't hear what they were saying.
And when you said walking around where?
His truck.
And just in that proximity of just his truck?
Yes.
Okay, sorry, continue.
So after he was walking around for a little bit, he kind of started, he being the state officer, started to walk back over to us, and he was kind of just giving us this look like, this guy is, there's something that's up. And before anybody could ask, or either of us could ask him what he meant, he walked back over to him. I was actually on the phone with my family when I was on my way home from work, which I hung up to call the police. So during this time is when I took that opportunity, and I kind of walked back to my vehicle, and I was on the phone. I called my family back to let them know what was going on.
And it was to let them know what's going on, or let them know that you were safe, or?
Correct.
Okay. And is that when you made this second call, the 911 call?
It is. I noticed from a distance that it was getting more tension, I guess. Couldn't hear the conversations, but I could see the hand movements and the gestures between the two of them. Again, I don't know what he was saying, but it was almost like he's trying to explain to him something, which is when I told them, I'm going to call you guys back. I'm going to call the police back because something else is going on, because he started walking towards his vehicle again, like the driver's side at that time.
And when you called 911 the second time, was it kind of the same manner you did the first time?
It was. I was just basically explaining to them what it looked like was about to take place, assuming and hoping that they would say, okay, well, we actually have an officer. He's literally right there. Given the time frame, I would have assumed that someone would have been there by then.
Okay. How many accidents have you seen before this one?
I mean, passed on the road, a few. Witnessed firsthand, none.
And have you ever been in an accident yourself?
No.
Okay. So this is the first time you're encountering any kind of accident really firsthand or close by?
Yes.
Okay. And you get back on the phone with 911, and what occurs then?
I'm explaining to them what I thought that we had learned was that the driver who had caused the original accident was potentially drunk.
And that came from what the state officer said?
Yes.
Okay, go ahead.
And as I'm explaining it to her, I notice that's when he completely gets in his truck. He starts trying to turn it on, and you can hear him like revving it to get it to turn on, which I think that all of us were shocked that it even turned on to begin with. And that's when he started to drive away.
And you said you were shocked. Why were you shocked that it started back up?
There was fluids everywhere. It was smoking. It was damaged.
Was there a major impact?
There was, yeah. I mean, the entire tractor trailer just shifted and rocked when he hit him.
And you don't know what speed he was going through the red light?
I don't.
Okay. But you did see the effects it had on the 18-wheeler? Mm-hmm. Yeah. And then you are on the phone with 911. You see him jump into his vehicle, revving it up. And what happens then?
I'm just basically just telling dispatch that that's what's happening. I am explaining to her he just got in his car, and she asked me if I was able to get the tag number as he's pulling away.
Were you able to get the tag number?
At that point, I wasn't, no.
Did it appear anybody had gotten the tag number?
No.
And
they were just trying to get out of the middle of the road.
So people were trying to get out of the way. Was anybody screaming, get the tag number, or?
I mean, at the time, all I could see was the state officer and the truck driver the state officer was kind of grabbing the truck driver, kind of telling him, to get out of the way.
Where was this truck driver standing?
They were, so if this was the lane where they were turning and the truck was kind of partially turned, they were standing at the kind of the middle part of the intersection, which would have been middle part of the tractor trailer, which is kind of in front of Mr. Herring's vehicle.
Okay. Did it ever appear that any of them might have been in jeopardy of being hit when Mr. Herring was starting up his vehicle?
Initially, it's not the first thing that came to, I think, anybody's mind. But then once he started revving it and just kind of took off, then yeah.
Okay. And then what happened?
So I'm explaining to the dispatch what happened, and as he's pulling off, she's asking me, was I able to get the tag number? Realizing I wasn't able to, I was already at my vehicle, and I completely got in my vehicle and went to go pull off.
Okay.
And at that time, the truck driver and the state officer was still standing over in the street, and he started waving me over, like calling me towards him.
Okay. And when you got up close to him, what happened?
I asked him, did he go straight? And he said yes. And he's telling me, he said, go.
So at that time, you were under the impression that he's a state officer sending you to get the tag, and 911 knows that you're on the way to get the tag.
Correct.
Right.
And when I was in my vehicle, when he was waving me over, his motions it was almost like he was waving me on. So when he brought me up, when I got up to him, is when he told me to go.
Okay. And he said go, or did he say something else, or?
No, he just said, good, go.
Okay. All right, so then now you're going in the direction they pointed you, and you're on the phone with 911. Was 911 saying anything?
No, she was not.
All right.
There was kind of silence from the time that she had initially asked me if I had got the tag. I was still kind of getting my bearings, and I just started repeating to her, telling her, okay, he's going down Clark Howell or Forest Parkway.
So you never heard them give a warning of not to chase, or?
No.
And having heard the tape, did you feel that you were talking over it, or you just didn't hear it, or?
No, I was explaining to her as we were going down the road. I'm explaining to her what's happening, and from how I remembered it, she asked me again, so were you able to get it? And I explained to her, not yet, but I am about to. And that's when she told me that she just wanted me to be safe. I told her that I understood, and that I wasn't chasing. I was just going to follow, to stay behind him, to stay with him until the police officer could get to us. So I was able to kind of accurately, basically just keep them in the loop, since they obviously weren't there yet.
Okay. So your impression at that point is that you're just going to get the tag, and then hopefully that'll be it? You just report the tag?
Correct.
Okay. And did 911 ever come on and say, hey, we've already got the tag from somebody else?
No, she never did.
Okay. So as you're getting up close to get the tag, what happens then?
As I'm getting closer, I explained to her that I had the tag, and she basically tells me that this is the way that I interpreted it, was that she wanted both of us to go back to the original accident site because police should be there by now.
All right. Did she say something before that about you just returning, or the only thing you heard was that both of y'all needed to be?
Correct. She just told me she wanted me to be safe. I told her I felt like I was safe. And that's when I told her that I was going to stay with him until an officer could get to us. And she said that that's what she wanted me to do.
At any time, did you identify you had a gun or was carrying a gun?
I didn't.
Okay. So you're following the individual to get his tag, and you get it, and then your interpretation of what was said is that they wanted both of y'all to come back to the scene.
Correct.
So what did you do at that point?
At that point is when we had both come up to the intersection, and I saw him stopped in the turning lane. So I turned as well, and when I stopped, I was under the impression, with me having 911 on the phone, that I could just be kind of like a messenger. So I took my phone on speaker, and I took it to him to show him that I had the police on the phone, and I'm telling him they want us to go back to the original accident site.
All right, at this point, y'all have not made contact, correct?
No, we have not.
So how far do you think you pulled over, the distance between you and his truck?
Well, he was in the turning lane, and I was in what would be considered like the right straight lane. And the distance between the vehicles were probably maybe the width of this table.
But there was no contact, correct?
No, there was not.
Okay. And did you have any fear that something was going to happen by walking up to him with the phone?
I didn't think I had anything to fear. I assumed that having authorities on the phone, explaining that to him, that would just mean, okay, we'll go back.
Because you had not heard what the interchange between him and the state officer, correct?
I had not, no.
Okay. And as you approached him with the phone, how did you have it in your hand?
I had it on speaker, and I was kind of holding it like in my palm, with it kind of resting in my hand, just like facing him, so that he could see it says 911.
Now, you mentioned that he was in turn lane and was stopped, correct?
Correct.
Did you cause him to stop?
I did not.
And why would he be stopped in that lane?
The only thing that I could think of was either he was merging and his vehicle finally gave up, or that okay, so the way that the lanes merged, I was assuming that he was either waiting for traffic, but then getting up closer, you can see all of the liquid, like underneath the vehicle, you can see the truck is smoking.
Okay, and you said earlier that it might have just finally exhausted.
Correct.
Okay.
I mean, and even when we were back at the original accident site, the state officer and even the truck driver, but they were adamant that they don't understand how this truck hasn't just kind of blown, was how they were describing it.
Okay, so you intend to walk up with the phone, tell them, hey, the police are on the phone. What happened then?
I was walking up to him, and I am explaining that I'm on the phone with the police and that they wanted us to go back to the original accident site. It's loud. We're near an interstate. It's a busy road, and I can't hear what he's saying to me. But as I got closer, I heard him asking me, "Who the F are you?" And I told him that I was nobody, but that I had the police on the phone. And that they wanted us to go back to the original accident site.
Okay. So you'd explain that to him. Did you have the phone close to you? Did you have it away from you? Where was the phone?
It was kind of not extended, but partially of the way.
Okay. And what happened then?
Apparently I was close enough for him to reach out the car, and he knocked my phone out of my hand, and he grabbed me by my wrist, and he pulled me into the vehicle.
Okay, now, you said apparently you got too close to the vehicle. Did it appear to you you were too close to the vehicle, or?
I wasn't thinking that I needed adequate space to stay away from him or anybody or anything.
Okay, and then you said he knocked the phone out of your hand.
Yes.
And then he grabbed you. You said one was on your wrist, and where was the other hand?
And originally he had just grabbed my wrist, and he had pulled me in the car, and at some point my shirt had gotten grabbed. Okay. And he...
Go ahead, I'm sorry.
He was pulling my wrist, and he pulled me in the vehicle, and he kept yelling at me, telling me, "I have something for you." And he used, I have something for you, bitch. And he's leaning, and he's reaching, and he's pulling. And at this point, I remember that I'm sorry.
Take your time.
I remember that he had let go of my wrist, and he grabbed me by the back of my neck. And it was as if he was trying to kind of keep a hold of me. The entire time I'm telling him, I'm thinking, I still have to be on the phone with the police. They have to know. I'm telling him to let me go. And that's when he hits the gas, and we go forward. I'm still in the car at this point, And while it only may have been a few steps or a few feet, when you are being held against your will and you have no idea what's ahead of you and you're looking down, it felt like it lasted forever. And I just remember it was like I saw my life flash before my eyes, and I thought I was going to go down Riverdale Road, hanging out the side of this car.
And the whole time, are you trying to get away from this situation?
I'm trying to pull away from him, yes.
And how did you do that?
My entire body was up against the vehicle, and I'm just trying my hardest to push away with any part of me that I can, whether it was my arms or my knees, trying to just put distance in between me and the vehicle, thinking I could get away from it, and was unsuccessful.
And at one part, you hear yourself screaming, "Get the F out of the car." What was going on then?
I'm thinking that I have a better chance of not being drugged if he's not in the vehicle.
Hold here is a bag that's been labeled with evidence that we're going to call it defense exhibit number 39, 38, 39. Okay, and as you can see, it's been sealed and not open. At this time, Your Honor, I'm going to approach the witness, although I'm not sure until I open it, she can identify it. Do you see the writing on this right here?
Yes.
Okay. Does that identify a article of clothing?
It does.
Okay. And at this time, I'm going to open the evidence. Appear to be.
Oh, I think there's an objection.
Okay.
Is there an objection from the state?
Yeah, I mean, he is not tendered.
I'm going to tell you what she Okay. I was going to show it to her to see. At this time, Your Honor, may I approach?
You may approach.
Do you see this shirt?
Yes.
Does that shirt look familiar to you?
Yes.
Is it an accurate representation of the shirt you were wearing that day of the
Yes. Yes.
At this time, Your Honor, I would like to tender what is exhibit defense 39.
Any objection from the state? No objection. Admitted without objection.
And I'd like to present it to or show to the jury the shirt she was wearing on the day of the incident. Was it torn when you were wearing it that day?
No.
When Mr. Herring grabbed you, did he tear it?
Yes.
And is this a fair representation of the rips and what it ended up being at the end?
Yes.
Along with the rips in that shirt, was there any other part of your body that had any kind of marks from where he grabbed you?
Yes.
Okay, where were those?
I had marks on the back of my neck and kind of scratches along my arms, bruisings on my wrists, and scratches along my chest.
Okay. Anything in the facial area?
Yes. I had a kind of a black eye, but a bruised eye and a busted upper lip. And other, I guess, like sore spots, like or bruising and redness around the edges of my face.
And all of this occurred while he was dragging you forward towards your vehicle?
Correct.
Okay. And you said he was making a statement to you of, I've got something for you, bitch. Was there any other statements made that you can remember this time?
No, he just kept telling me that kind of over and over again, and that I was nobody.
Now, what was he doing in the vehicle while this is all going on?
Before he punched the gas is when he was kind of turning his body and he was reaching behind him.
Did you see what he was reaching for?
No, I did not.
Did you see any of the contents of the inside of his vehicle?
During, no.
Okay.
I could see that there were things everywhere, but other than that, I didn't really.
Have you ever experienced anything like that prior to this incident?
No.
Okay. And then what happened then?
Well, after the reaching is when he mashed the gas, and when he mashed the gas, I, like I said, have no understanding of how far we went, how much farther we can go. At that point, I didn't know that we had stopped because we hit my vehicle, and that's when I drew my weapon.
Right, now you said mashing the gas. What did that sound like?
You could hear the truck just revving and hissing from like the liquids spewing, and it was loud.
And you stated that then you said you have a gun?
I did.
And what was your intent at that point?
My intent was that pulling it out, he would let me go, and I'd pull away from the vehicle, and that would be it.
Did you ever stop trying to pull away from the vehicle?
No.
And explain to me how you pulled your gun out at that time.
It was in my holster on my right hip, and he had a hold of me, and I pulled it out and immediately started trying to just continue to push against the door with it, like pushing away from him.
Okay. And as you're pushing away from the door, what happens then?
He grabbed my hand with the gun in it.
Okay, let me go. Which arm did you pull, or which hand did you pull the gun with?
It was my right hand.
Okay. And you said he grabbed your wrist. Which wrist?
He grabbed my right wrist.
All right. And how did he have that wrist?
Well, with one of his hands, he actually grabbed my wrist to pull it towards him.
Could you tell which hand or arm he had grabbed your wrist with?
It was his left, because he had a hold of it. He had released me with this hand from my neck to grab me with this hand.
Okay. And the gun that was outside the door that you're pushing away from, he got a hold of that, correct?
Correct.
And what happened then?
After he originally grabbed it and was kind of pulling at it back and forth is when he put his other hand on top, and he started trying to actually yank it away from me. And then he started to try to turn it, to pry it, almost like he was trying to pry it out of my hands so that he could take it away. And
which angle was he trying to pry it out of your hand?
like away from me, so it was this way.
Okay. And that obviously is not the way here a wrist is supposed to move, correct?
Correct.
Is that what caused the bruising or the...
It is.
Okay. And you said he's trying to push it this way and pry it out of your hand?
To me, it's what it felt like. Like he was trying to pry it out of my hand.
And you said another hand came over and grabbed it?
Yes,
Okay.
from the top.
Your Honor, so that I can get a good understanding and the jury can see it. If I may approach the demonstration of what she's saying.
You may.
This is a toy gun. Toy gun. And even though it's a toy gun, it does have a slide on it. As you can see, that it can pull back. There's nothing in this gun. It's a toy gun. So, if this is the gun that you have, he was pointing it, say I and him, in his seat. How did he have your wrist? Like this?
This hand was here, yes.
Okay. And the gun was here, and he's pulling you forward.
Yes.
And you said he had you here
But
on this?
he was closer.
All right. So, and he had your shoulder with this hand, or what was this hand doing?
That he let go
He let go.
once he got a hold of this wrist.
So he came.
And he
tried
grabbed
to
the
get-
gun.
All right, you tried to grab the gun like this.
Correct.
Okay. And where was your finger?
The same way that I have it now.
And when he grabbed like this, that shows his fingers are right there over the trigger.
Correct.
Is that a correct?
I mean,
So-
yes.
So it's possible any of the 4 digits got into that trigger.
Correct.
To get. Okay, thank you. So that occurred, and he's grabbing the gun like that. What happens next?
He's pulling at it. He's pulling at it, and I'm just yelling at him to stop, thinking that if I could just get away, it'll just be over, I guess.
Were you saying anything to him at this time?
To stop.
Were you saying it loudly?
Yeah, over and over again. Yeah, I was screaming it.
Okay. And then what happened?
As he's turning it towards, like that way, I'm being pulled, and I can feel myself like pressing up against the car, like my face is up against the door. And as he's pulling it is when the gun went off.
Okay. And you saw the pictures that showed your hand kind of pulled back. Why would your hand or arm been pulled back like that?
After it went off, my entire body kind of fell backwards. Like I was almost like I was falling over, and I was trying to catch my balance. And my arm was turned so far in that once it went off and I was released, it just kind of sprung back.
What was going through your mind at that time?
A lot. I knew that I was still had to be on the phone with 911, and that I was just trying to get away from where I've been trying to get away from for the last however many minutes, and that I needed to communicate back to 911 what happened.
So you picked up the phone and...
I turned and I picked up my phone that was on the ground, and I told her what happened.
Okay. At any time, did you look around for a shell? To
No.
pick up a shell?
No, I did not.
Were you concerned about a shell?
I was not at all.
Okay. And when you got on the phone with 911, you stated that he pulled the trigger?
Yes.
And what else did you state?
To her, I had told her that he had just pulled the trigger on my gun. And I remember kind of looking around, and I noticed behind me that there was someone who was standing behind me, and I asked them if they seen everything, if they would stay to, be a witness. And he was asking, like, if we were okay. He's like, are you okay? Is everything okay? And I told him, I said, I am, but no, he's not. And I asked the dispatch for an ambulance.
Okay. So your concern at that point was to try to get dispatch to send an ambulance out?
Correct.
Did you look around to see if anyone were close?
I did. And that's when I noticed that there were actually I mean, there were police that were, to me, felt so close that all of this could have just been avoided.
But you had no foresight or any kind of anticipation that it would conclude like this?
I had no idea.
And it appears that a lot of witnesses did come up to confront you or to say what they thought they'd saw.
I mean, originally, everyone that was standing around, they weren't like saying anything direct. Everyone was asking each other what happened. Everyone was trying to figure out, like, well, where did this car come from, and how did this happen?
Did any of them or one particular stick out to you?
Only the one that was right next to me, because I was assuming that he saw the whole thing.
And did you know his name at that time?
I did not.
After seeing him get up and testify, do you know his name?
I do.
And what was his name?
Cameron Williams.
Okay. And he did stay around?
He did. I don't know where he went exactly. He kind of started to walk around where everybody else was. And it was like I was still on the phone with 911, and I'm trying to explain to her what's going on. But at this point, I'm kind of in a bit of a daze. It was all over the place, honestly.
And what did you do with the gun?
I reholstered it. I took the holster off my hip, and I put it back in the holster.
Okay, and did it stay in that condition till the police came?
It did. I remember looking up and seeing that there was a police officer who was coming up from where he would have been at, like, the interstate area. And as he was walking up, I was trying to get his attention because he was, like, walking towards all the bystanders, having no idea what was going on, having no idea who was involved with what or where or how. And I was trying to get his attention so that he knew, here's the weapon, so that he could have it.
All right, now you said that a lot of crowds were saying stuff, trying to confirm what had happened. Did you hear all that they were saying?
It was more a bunch of kind of questions. After the police officer had come up, one of the people that was standing there were basically, again, asking what had happened. Did you, and she asked me, she said, did you just shoot him? And I told her, I said, no. I said, he pulled me into the vehicle. He had a hold of me, but that I never had my finger on the trigger.
And why is that?
I mean, number one, from training, and number two, I never had any intention on pulling the trigger.
And in fact, you never did pull that trigger, did you?
Correct.
Now, the officers, of course, came up, took your gun, and was there another officer that you encountered at that time?
There was. I was standing on the sidewalk. I was just trying to stay out of the way. And the original officer who I handed my gun to went into Mr. Herring's truck. Okay. And the other officer had come up, and everyone was kind of like, pointing towards me, basically. And he walked up to me and just told me that until they could figure out what was going on, that I would be detained.
Okay. So, as you said, kind of this fog's going on and you're in shock. Did you ever see that there was an opportunity to try to render assistance, or did that even cross your mind?
From the time that it happened to the time that the police officer got there, the initial response for me was I was away from this vehicle. And I wasn't trying to interject myself back into a situation that I had just got away from.
Okay. And when the other officer detained you, did he put you somewhere?
He did, in the back of the police car.
of what occurred, which you in the back seat. It may take you a second to use this technology. If you want to take a break or if they're ready to go.
Are you going to require any IT assistance?
I might. I've learned a lot on this machine, but I might. No, I wouldn't want to mess it up here. So yes, I might.
Okay. Ladies and gentlemen, I am going to give you a brief break. It's now 3:30. I just ask that you report back at 3:45. Thank you. Are you ready to proceed?
Yes, ma'am. I'm trying to be a step ahead and have the features pulled out.
Court appreciates that. Okay, I'm going to go ahead and bring the jurors in at this time.
All right. Get back in the statements, ma'am.
You may be seated. Thank you. You may proceed, Attorney Tucker.
Now, when we left off, I asked what happened once the officers came up. Officer Ritchie took your weapon, correct?
Correct.
And then another officer came and got you and was taking you to the car?
Correct. I mean, there was a little bit of time that went in between that, but from him taking my weapon to me walking, trying to stay out of the way, and I just remembered kind of going back and forth with the witnesses, talking about, again, them asking what happened. And I remember yelling for one of the officers to come up, and that we needed an ambulance. I was asking where the ambulance was.
Okay. And you do recall being placed in the back of a car similar to this, correct?
Yes.
And there was a video that you've seen prior to today that shows what happens in this video, correct?
Correct.
And I will show you a small bit, and then I'll stop it so you can confirm that that is the video that you recall of the interview with you after being put in the vehicle. Okay?
Okay.
The volume. Where's the volume? Here.
He's not allowed to do anything, but the deputy.
Is it on the computer? Oh, yes. Turn the volume. Oh, the speaker, okay. I won't be too loud. Oh, dear. Seems to be at 100. I should have turned off those. And I don't see where it's. All right. Does that appear to be you in the back of that car?
Yes.
Do you recall an officer coming up? You may not have seen him as well, but do you recall being in the back and having an officer come up and
Yes.
speak to you? And does this appear to be a fair and accurate representation of what it was when they came and talked to you?
Yes.
At this time, Your Honor, I would like to tender defense exhibit number 39.
40.
40?
Yes.
No objection, Your Honor, as long as we have, that we only play the times that we previously discussed.
Correct.
Yes. You don't know. And I'm not sure why the volume is not working. But of course, we need volume.
Hold on. It's
Got it here. Where's that 100%? Okay, go on. Podium. This one does. I don't see any light on this one. Right. So this one is I've got it. Going through the PC. The PC has volume all the way up. I've got the audio here. Podium. Amy? You think podium?
No, not podium.
Okay. I got the video from broadcast.
Okay, iTunes software.
And there's got to be video broadcast.
Did it play while we were on break?
Oh, we never got that the volume.
Okay.
The video plays, but volume did not.
Just crave everyone's patience while we get IT, who is here. Thank you.
And I'll come back and let you know what you think. Okay, I'm going to talk to her. Huh? Are they opening up that traffic yet? Oh, yeah, you don't get there and I ran up there, but I ain't no fool. Yeah, appreciate it. All right. How you doing, man?
So you said you recall that situation happening. That's fair, accurate representation.
Of him walking up to the car.
And
yes.
then, from what's going to occur here, I would like you to listen, please. And
Not doing good. I'm Sergeant Marion with Clayton County Police Department. All right. Can you just give me a clue and do you mind talking to me and telling me what happened? Okay. Take your time. Turning left on Board Parkway. Okay.
He ran to the semi? Okay. Okay. Okay.
Almost 20 minutes later, I called the police back and let them know that he was drunk and that he was out of his car. There was a police officer, I don't know from where, he showed me his badge, he was doing the whole thing down there as well. So he kept like, I don't know what he was jumping in the car, so he was starting to try to do it. So I jumped in my vehicle while I was going from the dispatch, and I followed him in the taxi. He was all over the road.
Okay.
And while I was following him, I was still in the letter, because I don't know, kind of talk about all the probably my dad knows I was almost in that.
Okay.
So I followed him down here, I got up and I was able to cut from him, and I told him to get out the car, he needed to stop the car.
Okay.
And I carried my left field on my right hand side. I told him I said, stop. Never once said I was short, never once said I did that either.
Okay.
When I got up to the car, I was on the phone with the dispatch, so I got up to the DPC that I was on the phone with her, and he smacked my phone out of my hand. So the words were said before that, but I don't remember. Smacked my phone out of my hand, and I told him he needed to get out of the car. And he grabbed my shirt, and he pulled on my shirt, and he under the button,
What did he have a hold of you in? Okay. Your hand? Okay. How did you grab your wrist? Did you reach inside the vehicle or what?
I was going like telling him,
Like pointing?
I was telling him to go over. And I was up at the window, and when he was grabbing a hold of me, grabbing a hold of my shirt is when I got closer to the window, and I was talking to him, and that's when I saw his hand, he was reaching, and maybe I'm assuming because I'm really reaching on him. I don't know, but that's where I wanted to get protection.
Okay.
All
I need is to twist it up. Yeah, you don't got to go that. They're gonna talk to you at CID. I just need to know what came up to when the weapon was fired.
I pulled it out and I told him that I would shoot him. And he grabbed me, my hand, where I had my gun, where I was holding my gun with that hand. He pulled me to him, and I'm pulling away, I didn't want to pull the trigger. He didn't have anything in his hand now. I can clearly see he doesn't have his gun. Wouldn't have anything on it. But he grabbed my hand, and we're going back and forth in the car, and he's pulling it, and he's turning it toward me, and he grabs it, and then the next thing I knew, it went off.
Okay. Okay, I got you. Did you still last 2 weeks? Okay, all right.
I stood back. I told him he was moving around. I told him he needed to sit still. That's when I was yelling at the dispatch to tell them to come back around. And I stood back in the roadster. I was just sitting there waiting.
Were you on the phone with dispatch at that time? Oh, the whole time? Okay, all right.
And I was on, when he came around the corner is when I handed it to him. And I told him, here's my gun. This is where it was shot. Here's my ID. Here's my ID.
Okay, all right. All right, thank you. You have the opportunity to call him. Just give him a minute.
Now, how do you take it out there? Just take it out. You just go it on.
You need some assistance?
Yeah. You want to stop.
You want to take it out?
Yes, ma'am. that what your recollection of the count, how it happened?
Minus details,
Okay.
generally.
Well, how were you feeling at that time?
I was overwhelmed. I mean, I didn't know what was really going on.
Is that why
I
you
was
wanted?
scared.
Is that why you wanted to call your parents? Okay. And they had some pictures earlier that were presented. If I may approach, Your Honor.
You may. Did you show?
Yes, I did. I showed some.
Okay.
What I have here is defense exhibit number 27, 28, 29, all the way through, appears to be 30, 35. You recall seeing those when I entered them into evidence, correct?
Yes.
I may present, Your Honor.
You may.
We'll just go in chronological order. Okay. Does this look like a fair and accurate representation of where it appears you were scratched?
Yes.
Okay, is that where when you said he was reaching for your head or trying to pull you in, that's where the marks came from?
Yes.
They didn't come from putting a sweatshirt on, did it?
No, it did not.
Okay. And this is defense exhibit number 28. Do you recall this?
Yes.
Okay. And this area here, is that, what is that?
It's my wrist.
Is that where the swelling or what?
Yes.
Is that your right hand?
I believe so, yes.
Okay. And that would be swelling for why? What reason?
Well, there was swelling on both, but on this side it was from where I was grabbed, but then my right wrist is where it was being like twisted and pulled
Okay.
and grabbed.
Is this another photograph of how your shirt ended up
Yes.
that day?
Yes.
Okay. And when they were taking pictures, they took a picture of here. What was going on there?
You can't really tell in this picture, but it was starting. It was hurting, like it was starting to swell, and there's irritation around it. I guess you could call it.
Okay. And do you recall them pulling out a ruler to measure the marks on the back of your neck?
Yes.
Okay. And you recall them taking pictures of your hand there?
Yes.
Well, hang on. Okay. And describe what was going on there.
There were like scratches and marks all along my hands and on my fingernails. There were a couple of them, and to try to remember now, I don't remember which ones, but there were a couple of them that were broken off when all of this was happening.
And there's some marks over here. Do you recall what those marks were?
The one right on the top was where Detective Moore basically was asking me if I was showing her where it was hurting, and in that area she wanted him to document that it looked like a busted blood vessel.
Okay. And do you recall seeing this being presented into evidence?
I do.
Did you ever see that in the vehicle?
Not at the time, no.
Was that the biggest nightmare you had if that was in the vehicle?
Yes.
Is there anything else? Is there anything else you can remember about that incident that you might have missed from seeing the back of the truck or at the back of the police car and speaking with them in those pictures?
Small details don't really resonate very well. I mean, it's been the only thing that I've thought about for the last 4.5 years, but it's not details. No, nothing that I can think of.
Now, did you get an opportunity to speak to other officers?
Yes, I did.
All right, and who was that?
After I was taken to the police station, they put me in a interview room, and eventually a Detective Hayward came in and introduced himself and said that he was waiting on his partner.
Do you recall who his partner was?
I was Detective Moore.
Okay. And do you recall how that interview went?
I remember feeling like I was waiting for hours. I didn't know what was going on. I hadn't talked to anybody since it happened other than the police officers. And I just remember like feeling like I was waiting for forever, and I had no sense of time or what was going on.
All right. While you were waiting, did you do anything while you were waiting and sitting there alone?
I remember pacing, and that's when I noticed that my nails were broken. So I started messing with my fingernails. I started like taking them off. One of them I remember was hurting, which is what made me realize it was broken.
Okay. And do you recall any of the conversation between Detective Haywood and Moore in that interview?
Not really. I remember that to me it seemed like they would kind of go back and forth between one being more interested than the other. And they kept asking me the same things over and over again. But every time they would ask me, they would kind of insinuate like a different narrative, which to me, I'm thinking that there's an obvious explanation that everybody that was sitting around would have been able to see what I said happened. So to me, I didn't feel like it was, I guess, logical. So I was just confused.
Okay. And you said they were insinuating that there was a different answer, or can you give an example of that?
I mean, if just trying to change like my wording, trying to, instead of when I explained to them that I was at the side of his vehicle, when they went back to repeat what I had said, they said, so you reached in his vehicle to show him your phone or something like that. And I just remembered, no, that's not what I said. I was trying to tell them exactly what happened. They kept stopping me, and then they would try and turn what I was saying, and then they'd pass it back to the other person.
Okay. At any time during this interview, did they tell you what was going on with Mr. Herring?
No, they did
never
not.
once said his status or?
Never. No. And I remember asking Detective Hayward in the beginning, kind of, is what's going on? Have you talked to anybody else? Like insinuating, can you tell me anything? And he just said, I feel like he kind of brushed it off and just said that he would have to see. And that's when I asked about calling, like my family.
So to your knowledge, through this whole interview, you didn't know the status?
I never
Mr.
knew.
Herring?
No.
And you were getting questions, as you said, from both sides?
Correct.
How did that make you feel?
In the beginning, when I was telling them what happened, I thought it was more of a kind of like a witness account, like here's what happened. As it got further into it, I could tell it, to me, it kind of started feeling like interrogation. But originally I wasn't thinking that it could have been an interrogation, because I'm just thinking that it was an incident that had a clear explanation as to what happened.
Have you ever been in a situation like that before?
Never.
And having gone through that situation and here we are in court, is there anything you learned from this situation or that sticks in your mind from all this 4.5 years later?
That not everybody is going to have a reaction that you think they're going to have, and that clearly trying to do the right thing is not the right answer.
Think you're ever going to help anybody else, try to help anybody ever again?
No.
Does the state have cross-examination? Yes, Your Honor. Okay. Take a minute. Are we still going to need IT right now? Do you plan to play anything else, Attorney Tucker?
I think we're back to the point. I think I know what we're doing up there. I'm not trying to say I'm an IT specialist, but I think we can handle it, and I don't anticipate.
Okay. If we need you, we'll call. Thank you so much.
All right, as you just discussed, you remember having an interview on May 7, 2019 with Detective Moore and Detective Hayward.
Correct.
And you recall during that interview when you were discussing the original incident that occurred on Clark Howell, that your vehicle was almost struck by Mr. Herring, correct?
Correct.
It was not struck.
No, it was not.
And that you were able to stop your vehicle before he came through the intersection.
Correct.
And at that time, you were able to go around and you pulled up on the sidewalk and waited to call the police.
Correct.
And while you were on scene at Clark Howell, you had no issues with Mr. Herring, correct?
No, none.
You never spoke to him directly?
No.
You didn't see any weapons on him?
No.
You never got close to him to smell any odor of alcohol on him?
No, I did not.
And he didn't threaten you in any way?
No, I did not.
And you never told the detectives or the police that Terry Robinson told you he was drunk?
I did, yes.
You told the police?
I told 911 dispatch.
Now let's talk about 911 dispatch. Now you also stated that when Mr. Herring took off from the incident location, you were already at your vehicle.
Correct.
And you had gotten into your vehicle, correct?
I was sitting in my vehicle on the phone, correct.
And Terry Robinson and Mr. Kimball were still in the street.
Correct.
And you stated that he waved you over?
Yes.
And the only thing you heard Terry Robinson say was, "Go, go, go."
Correct.
That's your testimony today?
Correct.
So he never told you to take a picture of the tag?
Not that I remember, no.
And you also testified today that you never heard the 911 dispatch give you a warning not to chase?
No, I never said that. I said that she told me that she wanted me to be safe. And I said that from what I took it as was that she didn't want me to chase. And when I explained to her I wasn't chasing, I was just simply staying with him until a police officer could get to us.
And the 911 dispatch indicated to you approximately 4 times to either not chase Mr. Herring and go back to the scene, correct?
Incorrect. I only heard it one time, and she told me not to chase, to be safe. She never told me to go back to the scene until after I had told her that I was behind him and that she wanted me to be safe. And in doing so, she said that she wanted both of us to go back.
May I approach the witness, Sharon? Excuse me. I'm handing you what has been previously marked as State's Exhibit 40, which is a copy of the 911 transcript. If you can review that.
It's in its entirety, or just what you're referencing?
You can review the entire transcript. You ready?
Yes.
All right, you see on page 1, female caller. Dispatcher tells you, okay, can you get his tag number? Your response, hold on, he's driving away. It's a red Dodge Dakota. Give me 1 second, hold on. Okay, so he is going west down Clark Howell. No, I'm sorry, down Forest Parkway. Dispatcher, okay, so you couldn't get a tag number? Your response, no, but I'm catching up to him right now. And the dispatcher tells you, okay, ma'am, we actually do not want you to chase him. We just want you to be safe. The first time they tell you not to chase him, correct?
She didn't tell me not to. She just said that they didn't want me to because of my safety. At least is the way that I interpreted it.
Okay, I'll give you that. So they told you that they do not want you to chase him, correct?
Correct.
And what did you say next? You can read it.
I understand.
Okay. And the dispatcher tells you after that, it's not safe to chase him. Second time, correct?
That's what the transcript guy said. When we're listening to it, I don't remember hearing that, but.
And can you read what your response was?
I understand 100%. I'm just going to get the tag number, if nothing else. But I am going west down Forest Parkway, and I'm almost up to him.
So you told the dispatcher that you understood 100%, correct?
That I needed to be safe, correct.
And the dispatcher states after that, okay, after you provide the tag number, which you provide the tag number before you make contact with Mr. Herring, correct?
Correct.
And once she gets the tag number from you, she tells you, okay, So if you could go back to that location where the incident happened because someone is actually on the way to you guys now, is that correct?
Correct.
So there should be no confusion that she told both of you to go back to that location.
Well, if you keep, it's not confusion, it's just more to the conversation.
But you said your interpretation was that she advised, you thought that she was advising you and Mr. Herring to return to the incident location, correct?
Because that's what she says in the next line.
Okay, I'll let you read it. Read the entire response from dispatch.
From what the transcript reads is, you know.
From the beginning, okay.
Female caller or dispatcher?
Dispatcher.
Okay, so if you could go back to that location where the incident happened because someone is actually on the way to you guys now.
And Terry Robinson and Mr. Kimball were still at that location, correct?
That was 2 out of the 4 people.
Terry Robinson and Mr. Kimball were still at that location, correct? And that's the 3rd time she's telling you to not continue to follow Mr. Herring and go back to the location. Correct?
No, that's when she told me to go back to the location, the first time. She didn't say anything about not following.
All right, and so what is your response to the dispatch at that time? You can read the next paragraph.
That there's a police officer. Okay, well, there is a police officer there, but he is drunk. I'm sorry, but I'm here to tell you I'm not going to follow him because he's going to cause another accident. So I will stay behind him until an officer can get to us. But until then, I'm not moving.
Right, so you were aware that dispatcher did not want you to continue to follow Mr. Herring, correct?
Sure.
Is that a yes?
Yes.
All right, and the dispatcher tells you after that, you know that's what I want. I want you guys to go back to the location where it happened and an officer will be out there momentarily. So that's a 4th time she's telling you again, don't follow and head back to the incident location, correct?
Incorrect.
Okay, so what am I missing?
She said, which in the transcript it reads differently than what you can hear on the call.
I'm talking about the transcript that's before you, Ms. Payne.
I'm just speaking from facts of what I've known.
I'm asking you to...
If she could allow the witness to finish answering the question instead of interrupting her.
The defendant is...
She could give her question answered if she allowed her to finish hers.
Your response, A.D. Hunter?
The defendant is not responsive to the question. I'm only asking her about the transcript that's in front of her.
So I'm going to overrule the objection, and Ms. Payne will answer the question that's been posed.
Okay.
You can explain after you've indicated whether she's correct or not correct.
So can you repeat your question?
The dispatcher, for a 4th time, indicated to you that she wanted you to return to the incident location, correct?
Correct. And not for a 4th time, that she wanted me to not follow.
Okay. You testified that you didn't cut Mr. Herring off on Riverdale Road. You saw him stopped in the turning lane. Is that correct? Is that your testimony?
I said I saw him stopped in the turning lane. And I never used the terminology cut him off. Because in my eyes, I was still in my lane of travel.
And do you remember telling the detectives on May 7th, 2019 that you got in your Jeep, you followed Mr. Herring, you told the dispatch that you were following him, and she told you that she didn't advise it. She told you to get his tag number. You got the tag number by the time you got to the end, right when I got to Riverdale Road, correct?
Your Honor, objection. This is a very long question. She can break it up. Maybe the witness could understand it and answer a little bit clearer.
Your response, Eddie?
And I'm asking her if that's what she said. That's a statement that she would have made to the detectives. I'm asking her, was that a statement that she made to detectives?
Okay, so I'll overrule the objection. It's not a compound question. She's just asking if that's actually what she said, so I'll allow it.
So if you're asking me if I remember word for word what I said 4.5 years ago, I can not say that I do remember exactly what I said.
And do you recall that you told them that you came around that curve and you had an opportunity to get in front of him?
If that's what I said, then I don't remember. Like I said, exactly. It was 4.5 years ago. There was hours worth of interview. So.
And do you recall telling the detectives that you got in front of him and I stopped in front of him and I got out?
Okay.
You recall that?
Again, I don't remember word for word what I said. I would have assumed that I would have explained what happened, which you were able to see in the pictures.
So it's your testimony today that you did not cause him to stop his vehicle?
Correct.
Showing you what has been admitted as Defendant Testifies. Is that your Jeep?
It was.
And do you see how your vehicle is angled toward the red Dodge Dakota?
No, I see his vehicle is angled towards mine.
Okay, I can give you a better view. Showing you what has been previously admitted as State's Exhibit 8. Now, is your vehicle slightly ahead of Mr. Herring's vehicle?
Slightly ahead, yes.
Mm-hmm. And is your right passenger tire turned towards the right toward his vehicle?
The tire's turned, but the vehicle is not.
And so in order for you to get in that position, you had to turn your steering wheel to the right towards Mr. Herring's vehicle, correct?
Towards the lane.
And his vehicle is in that lane, correct?
At the time, it was further back, so no.
So if it was further back, you had to turn your vehicle in front of his vehicle, correct?
No.
So how did you end up in that position?
In this meaning, like with the cars connected or with me?
With you partially in his lane.
With my front tire partially in his lane, my wheel was turned.
Now, you testified that you walked up to him and you were, does it sound like you described it, calmly telling him that the 911 dispatch wanted him to go back to the scene?
Correct.
And telling him calmly that you were on the phone with 911?
When you say calmly, do you mean like was I irate or was I louder?
That is your testimony today that you did not get out of your vehicle and run up to Mr. Herring's vehicle telling him to get out of the car.
Correct.
And you never once got out of your vehicle and go up to him and tell him to get out of the fucking car.
what everyone heard I did.
And so at no point on that 911 tape did you ever tell him to stop,
I
go
did.
back to the scene?
I did.
And did you hear that on the 911?
Conveniently, no.
Okay.
And so I believe you testified that as you were at Mr. Herring's window, his vehicle moved forward towards your Jeep, correct?
I was in the vehicle, but yes, correct.
While that vehicle was moving forward?
Correct.
So do you remember speaking with the detectives? Okay. May I approach, Your Honor?
Yes, you may. I'm handing you what has been previously marked as State's Exhibit 41, which is a copy of the transcript of your interview with Detective Moore and Detective Hayward.
Can you turn to page 11? The page number will be at the top of the page.
Okay.
And down at the bottom of the page, where it says your name, and it starts with "and."
Yes.
And can you read that paragraph?
And he's just like, who are you? Who are you? I said, I'm no one, but I'm on the phone with dispatch. I'm on the phone with the police. You need to stop. You just caused that accident. And he's like, yeah, okay, I got something for you. And that's when he pulled forward.
And Detective Moore asked you, so at this time, it was just words being exchanged. There was no, he stopped, and then what did you respond?
She stopped, and I responded saying, no contact.
And she responded, no contact at all yet. And what was your response?
Right.
So at the time his car pulled forward, there was no contact between you and Mr. Herring, correct?
It was between the vehicles.
So when Detective Moore said there were just words being exchanged, there was no contact. Is
That's
your
what she
position
said.
that she was just talking about the vehicles?
That's what I would assume, yes.
So words and vehicle?
Yes.
Where's the question at, Your Honor?
Your response is your contact.
I'll move on, Your Honor.
Okay, I will sustain the objection. You can move on with your next question.
Now, is your testimony today that you've never had your finger on the trigger?
It is.
Can you turn to page 49?
Okay.
All right. Down at the bottom of the page where you see your name and it starts off, I mean. Can you read that paragraph?
I mean, he's almost fully turned by pulling, and I think that was more so just a matter of us kind of going back and forth with him like this. Hannah is showing the position he is in. And he's pulling, and after he tried to pull the trigger, when he came back around is when I had my hand on the trigger, and he still was squeezing, reaching, pulling, turning. But I'm pretty sure that in prior testimony we were speaking of the trigger guard.
And can you turn to page 41?
Okay.
Can you start down where it says your name? I pulled it out.
I pulled it out and I had it up here.
And Detective Hayward asked you where the muzzle was pointed. What was your response?
It's more so pointing sideways.
And he also asked you that he stated so it was not pointed at Mr. Herring, just raised.
Correct.
And he stated ready if you had to pull it.
That's what he states, yes.
And on page 42. And Detective Hayward states that he reaches out with his right hand, so you know there is nothing, no weapon or nothing in his right hand, correct? And what is your response?
Correct. Well, yes, yes.
And Detective Hayward asked you because you didn't see no weapons or nothing in his right. And what is your response?
I didn't see anything in his, but he didn't have anything in his hands.
And on page 40, turn to page 40. And at the top, I believe that's your response. And I had it, my gun in my hand. And Detective Hayward asked you, are you pointing it at him at this time? What was your response?
No, I am not pointing it at him, but I'm pointing it away.
No, reread that. I don't believe that's what that says.
I'm not pointing it at him, but I'm not pointing it away. Where it goes on to show that I was resting it on the window of the car. As I explained, I was pushing away.
And so your testimony today was all of this could have been avoided, correct?
Correct.
And you also stated that you had no intention, or you wasn't trying to interject yourself in a situation that you just got away from, correct?
Correct.
But that's in fact what happened on May 7, 2019.
Interjecting myself twice or initially?
So in the initial incident, your vehicle was not struck, correct?
Correct.
And so there was no reason for you to interject yourself in the final conclusion of what happened with Mr. Herring as far as that incident was concerned.
Well, there was a lot that led up to that. So for me to have interjected myself to begin with was me doing something that I would have wanted someone else to do for me, which was to be a witness for what I thought was an accident.
And you're not post-certified?
No, I'm not.
You're not a police officer?
I'm not.
Nobody deputized you on that day to apprehend anyone?
No, they did not.
And you also stated that you never had any intention of pulling the trigger.
Correct.
So when you told Mr. Herring that you would shoot him, you were just bluffing?
Oh, it's not. I wasn't bluffing. I was, as I explained, thinking it was a deterrent, like I would be able to get away.
And you said you had training with this firearm?
Yes.
And in that training, you didn't learn that you don't pull a gun unless you're going to use it?
I learned that you don't put your finger on the trigger unless you're going to use it.
And it was your testimony today in that interview that your finger was on the trigger, correct?
My finger was in the trigger, on the trigger guard, not in the trigger.
Thank you, A.D. Hunter. Any redirect?
Yes, ma'am.
Attorney Tucker.
Yes, ma'am. Okay, now they talked about this 911 tape with you. During this 911 tape, as you heard it while you were sitting at the table, did it appear sometimes you were talking over the 911 operator and they were talking over you?
It appeared that way, yes.
Okay. Did it appear that when they were saying one time, we don't want you to chase, we want you to be safe, that you were giving directions at that time?
Correct.
Could that be the reason you did not hear the first or the second time?
Correct.
Okay. Now, the state kept saying that they said, don't chase, don't chase. But you recall them saying, be safe and come back to a location, correct?
From my recollection, I remember them telling me not to chase. I told them I wasn't chasing. I was just following behind. She wanted me to be safe, and I told her that I understood that. I had no reason to think that I wouldn't be safe.
Okay. And the last time from you saying, I'm just trying to get his tag, how many seconds went by before 911 came even back on the line to talk to you?
There was a large gap between both times of her originally asking me, can I get the tag? And I said, no, hold on. There was a large gap. And then she asked me again if I was able to get the tag. And there was another large gap.
Right. And I recall hearing you walking at a fast pace to your car, to your Jeep, while they were asking about the tag. So did you get into your Jeep at that time?
Yes, because I was sitting on my passenger side, or standing at my passenger side.
And you were on the phone concentrating to what 911 was saying, correct?
Correct, yes.
Did you hear any outside noise of the state officer telling somebody to take a picture of the tag or to get the tag number?
No.
So you were doing what you were told to or requested to by 911?
Yes.
Okay. Now, state asked you a specific question, and I think you read the transcripts of you never had your finger on the trigger. But isn't it true that the portion you read said your hand was on the trigger?
That's the way that I interpreted it, which is why I tried to explain about the previous statements.
Is your hand different than your finger?
It's a part of.
Okay, but it's different when you're holding a gun to have a hand versus a finger on a trigger, correct?
Correct.
And do you recall anybody ever coming in there to get fingerprints to check the trigger to see if there were any fingerprints on the trigger?
No, they never checked for fingerprints. They never took my fingerprints. They never even checked the fact that I had the marks or the ripped shirt or anything like that until way after.
And did you request them to take pictures or to check that, or did someone else?
Detective Moore is who actually asked the photographer to come in after it was brought to her attention.
And you mentioned that they were going back and forth, Detective Moore and Detective Haywood, correct?
Correct.
And was it kind of a good cop, bad cop situation?
In hindsight, yes.
Okay. And did it appear they were looking for a certain answer, or they were changing the words to get that answer?
That's how I explained it. That's how I felt.
Okay. And now you stated that there was no contact, and you stated you thought it was the vehicle, correct?
Correct.
Was there any contact with the vehicle prior to the question they asked?
At that point, there was not.
But was there? Had he grabbed you or done anything to you prior to that?
Prior to what are you referencing?
To the vehicle moving forward and hitting your vehicle. And that's the contact you thought they were talking about, correct?
Correct, yes. So when he had a hold, and then once he grabbed a hold of me, after that is when the vehicles hit, which I didn't figure out until after the fact, of course.
Now, it said you pulled it out and possibly had pointed it sideways, but the gun would have been sideways, you stated, pushing off of the car, correct?
Correct.
So is that when he grabbed your wrist?
Yes.
So the gun would have been pointing kind of upward or downward, not at him when he grabbed your wrist, correct?
Correct.
Okay. And when he grabbed your wrist, he tried to pull the gun into... It's cross, Your Honor. I'm sorry, I thought in cross you can ask leading questions or ask questions about what they
You're
asked.
redirect. At this point, you're not cross-examining, you're redirecting. So I will sustain the objection as to leading question.
So what was the position of the gun as was asked by the state when it was resting on the boot?
It was in my hand, and I was like this. So it was like towards the steering wheel, I guess, is where the natural position would be until it was grabbed. And then once it was grabbed, it was back and forth, but inevitably in the end, it ended up to where it was being pulled that way, like away.
And you were asked about hearing your voice on the 911 tape. Did you hear your voice saying stop on the 911 tape?
I couldn't hear any of my, what I consider cries for help on the 911 tape.
Do you recall a Cameron Williams that came and testified that had a video?
Yes.
Okay. And do you recall after the state had taken him back to refresh his memory, and then he came back to finish his testimony? Do you recall hearing the video?
I do.
What did they say in the video?
You can hear me saying, stop, stop, over and over again.
And the phone was right there, close to you?
It was.
So, obviously, it just wasn't loud enough to be on the 911 tape?
I mean, my voice projection didn't change from me yelling from get out of the car to stop. So I don't know how it picked up one and not the other.
And it stated, the state requested that this could have been avoided and asked you that question. Do you recall that?
I do.
How could it have been avoided?
Initially, me not trying to do the right thing. And in the end, I don't know, just trying to stay away from the original scene, put it that way.
Okay. So, you said at the beginning, but at the end, it could have been avoided a different way?
I believe if he wasn't trying to take it from me, it would have never went off.
And you would have never pulled it had the situation not escalated?
Correct.
Okay. And you told the detectives, as well as the 911, as well as the people around there, that you never had your finger on the trigger?
Correct.
And if anything, your hand was on the trigger guard?
No, but that's where your hands rest, is alongside. Yes.
Thank you. No further questions?
Thank you, Attorney Tucker. Anything further from the state?
Very briefly, you talked about the fact that it could have been avoided had you not attempted to, I guess, assist or help. But this actually could have been avoided if you not had introduced a gun into this incident, correct?
I introduced the gun to try and save my life.
Nothing further, Your Honor.
And just briefly, she asked the question to interject yourself.
Objection. What is the objection? He's already directed the witness, Your Honor. He already redirected the witness.
And you're saying I can't come back and redirect again what you've done another question, round of question?
I'm going to sustain the objection, Attorney Tucker. Just, have you concluded with this witness, Attorney Tucker?
Obviously, yes, ma'am. I'm getting the witness.
Okay, you may step down. Does the defense have another witness?
Not that should have, there's, Your Honor, no.
So the defense rests at this time?
Yes, ma'am.
Okay. Does the state intend to use any rebuttal witnesses?
Yes, Judge.
Okay. Can counsels please approach? Council's approach again for just a minute, please. Ladies and gentlemen of the jury, I am going to release you at this time for the evening and ask that you return tomorrow at, well, hopefully you'll get here by 8:30 so that we can promptly start at 9 o'clock. You are released for the evening with the instructions that I previously gave. They still apply. No discussion, no social media searches, all the instructions that I've given. And hopefully you'll have a good evening, and we'll see you back here tomorrow at 8:30. Thank you so much. So, just to place on the record what was discussed at the bench, we're going to conduct the charge conference or pre-charge conference at this time. The state will call its rebuttal witness tomorrow at 9 o'clock, but at this time we can go ahead and look at the charges and determine what will be read to the jurors tomorrow. Attorney Tucker, were you able to receive a copy?
Yes, ma'am. I believe the clerk came out and made a copy for everyone to find.
Okay.
I'm not sure if she gave it to them or not. I think what was discussed in her email is kind of similar to what I wrote all over the paperwork, and I agree on some of the, I think on the majority of the issues brought up, I agree with. And mine are just notes on the charge itself, because there's duplicate charges, there's gaps, there's some other stuff. So I think if we go through and make sure that every charge is correct the way it's said, and some of ours are the same, I think we can go to the order of what it needs to be, and that should satisfy that. I don't think there's something that I'm going to jump up and really object to, because all of it looks like pattern.
Okay, all right, so I'm going to step off the bench for just a minute. Let me just see if the staff attorney is here so that we can go ahead and try to handle this portion of it. For those of you that are sitting in the courtroom, pretty much we're recessed in terms of evidence. We're just doing charges, what the jury will be charged with. So you're free to remain here or you're free to leave. This is just something that the court has to handle with counsels at this time. So I'm going to step off for just a couple minutes, and then I'll be back to review the charges. Was the state able to send any revisions to the staff attorney?
Yes, I've sent my revisions to the staff attorney and defense. I don't have any of their suggestions or their requests at revision.
Nothing from defense attorney?
I have his original request to charge that we both did in October of 2022. But I don't have anything, if there's something more important, I have what he emailed, but his comments and suggestions and things along those lines, I don't have.
You do not have.
I do not.
And I believe the staff attorney came out this morning, taken my copy and made copies for all parties. That was my understanding, and she came back later on and gave me my copy back.
Right, but did you email anything to Chief Assistant or to ADA?
I emailed and explained that I made my corrections on these documents, but it was similar to her comments and documents, and that I would have this present and available. And that's what I was understanding the staff attorney did, was make copies for all parties.
Okay.
But there's
All right.
similar comments and similar statements that I think we sit there and just go through it, we can knock it out, there's not going to be much objections.
Okay, all right. Give me a second. I'll be right back. My understanding is that Staff Attorney Boga forwarded it to your emails, so you should have that. Are you on page 1? The indictment accusation.
Don't have enough screens to have my comments in return.
Okay. So I will correct the second line of the first page. That should be malice murder. So I will correct that. Well, let me ask you, is this something you want to look at this evening and we can go through? Okay.
We're just trying to use 8800's screen to pull up.
Okay. So the first 4 pages are just, it's just relisting the charges, the counts. Okay, page 5 is issue and plea of not guilty. Are we okay with page 5?
There's no objection to that one.
Okay. Defense counsel?
Yes, Your Honor.
Can you turn on your mic?
You don't have a
Mic.
computer?
Can you turn on this mic?
Yeah, I guess.
Right, and just speak into the mic,
Yes, turn it
Attorney
on.
Tucker, just so that court reporter can record.
Yes.
Thank you.
It's not on.
It's on now? Okay.
Yes.
We're on page 5. Are you okay with page 5, issue and plea of not guilty?
My understanding of what the pattern was, I believe that is fairly close, if not exact. I believe there was something else there, and I was trying to check it with the issue.
Judge, on that, this is, that looks just like the state's request to charge number 2, which is the pattern. So the charges are in pattern.
take that as okay. Page 5.
And if they're saying it's the time, it appeared.
Okay.
Okay.
Page 6, the presumption of innocence, burden of proof, reasonable doubt. Any corrections?
Judge, this is the pattern, and it does contain the correction that the state pointed out, just reflecting the defendant's gender. And that change in the original is, you can see it highlighted in what Ms. Boga just sent us.
Okay.
I just changed it from a his to a her.
Okay.
So no objection, it's the pattern charge on presumption of innocence, burden of proof, and reasonable doubt.
With that change, no objection.
Okay. Page 8, jury, judges of law and facts.
That is the pattern charge 1.20.30. The state does not object to it.
Okay, what did she quote as Chief Assistant?
I was just quoting the pattern charge because they appear to be looking at it, so I was trying to help them find it.
Okay. Be so kind as to repeat.
Yes, it's the pattern is 1.20.30. The state requested it, so we don't have an objection to page 8.
Objection, it is a pattern.
No objection is what you just said, Attorney Tucker?
No objection, Your Honor, it does appear to be a pattern.
Okay, thank you. I gotta be able to hear you, Attorney.
Yes, ma'am.
Okay.
I rarely have that problem, so
Okay.
I'm talking to the mic.
Don't stop making it a problem now.
All right.
Okay, page 9, evidence generally.
That is pattern 1.30.10, and that is the pattern charge. State does not object to page 9.
There is a part that's in quotes. I'm trying to see if that would have a bearing.
I don't have anything in quotes.
Right, but in the pattern there is quotes talking about stipulation of attorneys, that is, any facts which the attorneys may agree upon with the approval of the court, matters which the court has taken judicial notice, and I don't think we had any, so I have an objection. I just wanted to read that.
Okay, so we're okay with evidence generally, page 9?
Yes.
Okay, thank you. Page 10, direct and circumstantial evidence.
This is the pattern 1.30.20. We do not object to page 10.
Okay.
It does appear to be a pattern no longer, no objection, right?
Okay, thank you. Page 11.
Judge, on page 11, the state's request is the current pattern. The state opposes giving the defense request a charge there. Number one, it would be redundant at the state's request. Number two, the courts have disapproved of some of the language that is contained. We are no longer to charge, and it says it in the charge book, to no longer give the charge about a witness's intelligence. So the state's request is the current pattern, and we would ask for the current pattern and not the old charge that has now been disapproved of.
Attorney Tucker?
I see what they're saying, their intelligence, I understand that. could be some more language left in there.
So I'm going to go with, pardon me?
It just appears, there's more words, but actually I'm reading it covers the same basis.
It covers the same thing, so yes. I'll go with the first one. So we'll take out the defendant's request to charge number 4. Page 12, expert witness.
Judge, I'm sorry. That is the pattern charge zone. The highlighted sections where I added commas, but other than that, the state does not object to that. It's this pattern charge on expert witness.
Okay.
No objection, Your Honor.
Okay, so included. Page 13, witness impeached.
This is 131. Are you looking at pattern?
Yeah.
It's 131.45. But it's tailored to the evidence. The pattern charge contains methods of impeaching a witness that did not occur here, such as prior convictions, things along those lines. So it's the pattern as tailored to the case.
And I would request that portion to remain in there based on inferences that can be made from statements back and forth. In particular, I know it has no bearing because I know she would do nothing inappropriate, but she did talk about Mr. Cameron having a DUI ending. And even though we didn't go down that road to really harp it, the jury heard it. And just to be fair to both sides, I would request that you keep that portion in there. I don't see where the harm would be by leaving it in there.
That portion talks about a person having a felony conviction.
A conviction.
Where?
His case is still pending.
Yes.
So it wouldn't be applicable. So he doesn't have a felony conviction. So I am going to give the 131.45 witness impeached.
With or without the...
Without, because he doesn't have a conviction. He has pending charges but no conviction, so it wouldn't be applicable. Okay, page 14, prior statements.
No objection from the state. It's what was emailed to us. It's not just my request. It's what was emailed to us a few minutes ago. A little while ago.
I'm sorry, Your Honor, I was looking at a different copy. What was
A different copy of what was sent?
I do, Your Honor, and I'm pulling it up right now. I was looking at the over here.
We haven't got there yet.
Okay. The copy I'm looking at here says, witness impeached, immunity leniency in prior statements.
Yeah, I'm going in order based on the pages. So the last was witness impeached, and then we're now at prior statements.
Okay.
Page 14. The last version was sent approximately 3:49. Is that the one you're looking at?
That's I'm trying to find the attachment to it. So see what was sent.
Pardon?
There it is. I see it.
You just
This was sent.
re-emailed it?
Yes, I see it. I've got it. There were a lot of attachments to that chain.
Okay.
So I've got it now.
So we're on page 14. Prior statements.
Yes, ma'am.
And is the pattern charge?
It is 131.47.
Did you say 47?
It's 1.31.47. And state agrees with that page.
And it does appear to be pattern, no objection.
Okay. Thank you. Page 15, single witness corroboration.
Judge, that is the pattern 131.90. I requested some redactions that have been made by counsel. It looks like I had used a charge I had prepared for a sex offense case, so it had some language about how statutory rape has to have corroboration. So I had requested that language to be removed. It has been, and so we approve of that, how it appears now on page 15.
Okay. Attorney Tucker?
It's as she described it. It's that way. It's a pattern, so no objection.
Okay. Page 16, statement of defendant.
State is going to play her statement tomorrow, so that will be applicable. No objection to page 16.
No objection, Your Honor.
Okay. Thank you. Page 17, voluntariness defined.
No objection to page 17.
And I see the necessity of the prior charge. I'm looking at a different charge. And it just appears to be worded different. I don't think it's substantive different. It just appears to be worded different. All right, no objection.
Okay. Page 18, burden of proof as to voluntariness.
The state does not oppose that paragraph. However, there is more to the charge that needs to be given, and it needs to be given in conjunction with this paragraph. So moving on to identification is the inappropriate time to move on to that. What should come after burden of proof as to voluntariness, which is 132.19, should be the section on the defendant's constitutional rights, which is 132.21. So we don't have a problem with that paragraph. It's just identification should not be mixed.
So you're saying just burden of proof as to voluntariness, and then defendant's request to charge number 8 should be taken out.
Of that location.
Of
it
that
should be given at some point, just not there.
Okay. But you're okay with burden of proof as to voluntariness?
Yes.
And you, Attorney Tucker?
I I agree that the burden of proof, that is a charge, a pattern charge.
So we just place defendant's request to charge number 8 elsewhere, identification and burden of proof.
So, I'll put in, let's explain, okay, I can see the middle, no objection.
Okay. Page 19, defendant's request to charge 12 constitutional rights. There are 2 there.
Yes, Judge, I tailored obviously mine still has my red and my edits, which obviously should be removed, but I tailored the defendant's request, I think just because it was the one at the top of the page, by gender, and then I also adjusted it because the pattern charge says in paragraph 2 of the defendant's rights that if the defendant chose not to remain silent, anything she said, wrote, or signed, I took out the word wrote because there is no written statement that has been tendered. So what I have at the top of page 19 is what I adjusted to the evidence, and it's the defendant's request to charge that I happen to get to first and adjust, but otherwise it's the pattern.
Okay.
So we
So
don't
we're
object
going
to
with the first version.
the defendant's version is fine, Judge.
Okay.
And with the small correction she made.
So we'll just take out the commentary.
Yes, and then the second.
And the second portion, that's deleted. Okay. Page 21, burden of proof as to rights.
State agrees with this, Judge, and we'll take out our commentary.
The commentary. Okay. And Attorney Tucker, it's page 21.
Yes, ma'am.
Are you good with that?
Yes. I'm sorry, I was reading wrong. Yes, ma'am, that's a pattern, no objection.
Okay, thank you. Page 22, conditions precedent, consideration of statement.
That is what, that is the pattern, Judge. The only change made is the state removed some brackets to include language that should be included, and that's all.
Okay, are you referencing the last sentence?
Yes, there were some brackets.
Yeah, so is that the portion that's highlighted except for purposes of attacking the credibility of the witness or impeachment? Is that what you're referencing?
Yes, there was a bracket at the beginning of the highlight and a bracket at the end, and because we didn't actually tender it, the defense did put in the statement in the back of the patrol car. We put in for, it's
included?
Yes.
Okay.
That should be.
Minus the brackets. You're good with that, Attorney?
Right, and I just, you make a reference to a highlight. I don't see highlight on mine, but I do see what was intended. I just see
okay.
What was added. I have no objection.
Okay. 23 is blank, so we remove that. So page 24 would actually be page 23, DNA entry.
That's the pattern. State does not object to that page.
No objection.
Okay. Page 25, definition of crime.
That is the pattern, no objection to that page.
Attorney Tucker?
I'm sorry, she was coming down. I was pointing up here.
Okay. It is pattern, so let's move along.
Or admission of an act. And joint operation of that or intent. And what that looks like is you have to do an addition of an act and intent of criminal neglect. Addition of an act. I would request that I see where it's got one that possibly could be the other one that could.
I can't hear you.
I'm looking at here where it says admission to act or the criminal neglect. I'm trying to decide if I want those in there or not. I think.
It just simply states the defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of the state in which there is a joint operation of an act and intention.
But then this, I'm looking at the pattern says of an act or omission of an act and intention or criminal neglect. I'm trying to run through my mind if that's something that needs to be in there or not.
She has not been charged with anything that's an omission, and she has not been charged with any level of crime that is criminal negligence.
And that's what I was trying to get my head. And I think that's kind of the approach I would take. Your Honor, so no objection.
Oh, you're objecting?
No objection.
No objection.
I just want to get through my mind, think it out. Because I didn't hear anything about it.
All right, 26, intent.
It's pattern, no objection from the state.
No objection, Your Honor.
Okay. 27, no presumption of criminal intent.
It's pattern, no objection from the state.
It's the same, Your Honor. No objection.
Okay. Page 28, presumptions and inferences.
Pattern, no objection from the state.
No objection, Your Honor.
Okay. Thank you. Page 29, venue.
Pattern, no objection from the state.
Pattern, no objection.
Okay. 30, malice murder.
Pattern, no objection.
It is pattern, so I am going to give that charge.
I'm just trying to see if it looks a little bit lengthier than what I thought I saw in the pattern. And she's trying to get it there, just.
And we'll go through everything. If you decide that you have an objection tomorrow, you can always voice it. Attorney Tucker, I'll give you that opportunity.
Yes.
I am going to accept that charge. Motive, page 31.
Pattern, no objection, Judge.
Yeah, on that malice murder, you see a portion.
There is an objection.
I'm trying to read this, like I said, looking at it on the phone, looking at it here, it looks a lot longer, but I just want to make sure there's no added word. And it appears.
Okay.
Okay, so there's nothing with the malice murder, no objection, Your Honor.
Okay, and
The
motive.
motive, I don't know. It says pattern, no objection, Your Honor.
Okay. Page 32, felony murder.
It is the pattern as tailored to this case with the two underlying felonies listed, so no objection as it's written.
Okay, it is pattern, so I'll go ahead and accept the felony murder charge. If for any reason you object, Attorney Tucker, you can just voice that objection tomorrow.
Thank you.
Page 33, causation and felony murder.
It's pattern, no objection. And most of these charges that we're going through have been requested by both sides, so no objection.
Okay, all right. So we can, since most of them have been tailored in terms of gender, you may find the defendant is guilty of felony murder if you believe that. I'm going to take out that he and just leave she cause the death of another person.
Yes, Judge, and I think it might be appropriate because I put a slash between the two felonies. I don't know how you want to say, if you want to say aggravated assault or false imprisonment. I didn't put a conjunction there, I just put the slash.
Okay, is that under causation and felony murder?
It's under causation, it's on the second line.
Right, okay.
By committing the felony of, and it says aggravated assault / false imprisonment. I don't know if I think an or might be appropriate there versus, because you can't read the words, read slash.
Okay, so we'll insert or and take out the slash. And this is acceptable by the state?
Yes, Judge.
It's a pattern charge. Any objection? Attorney Tucker?
And you you gonna replace it with and or are you gonna, I see what you put it together to kind of.
You're asking for an and or?
No, ma'am, I'm trying to figure out what she said is always.
It's the second line. It says aggravated assault, and then there's a slash, false imprisonment. The recommendation is to take the slash out and put or.
And why are they being combined instead of separate?
She doesn't have to read the charge on causation twice. There's the causation for the aggravated assault, felony murder, and the causation for false imprisonment, felony murder is the same.
Correct.
So rather than read the charge twice just to change the charge, she's just putting in the or.
So I'm going to accept causation in felony murder charge. That's page 33. Is the pattern charge. Page 34.
Judge, I'm sorry.
Yes, go ahead.
I think it's appropriate on page 34 to take out the bracket. It says with a deadly or offensive weapon. She's not charged with offensive. So I just think just call it aggravated assault and then read the language.
So take out everything in the brackets.
Yes, Judge.
Okay.
I don't want them to think there's more than one way, that they can find any other way of her committing aggravated assault except for with the deadly weapon as it's charged. Everything else is pattern and no objection.
Okay. Any objection, attorney?
That is correct, Your Honor.
Okay. All right. So page 35, false imprisonment.
The only correction that I would make is change the he after the comma to a she. But other than that, it's the pattern, no objection.
So it's acceptable to the court. It's pattern. Page 36, firearm during commission of crime, possession.
The only, I would request, the state's request only because they have to be told that the offenses charged are felonies because it's possession of a firearm during the commission of a felony. And so they have to be told that the offenses, I mean, I think it's obvious, but that the offenses of malice, murder, aggravated assault, and false imprisonment as alleged in these separate counts are felonies.
That's, you see that that's
Okay, so we'll delete the commentary.
Yes.
And then you have the offenses of malice, murder, / aggravated assault / false imprisonment of alleged crime. These counts are felonies. Do we want to keep that / there, or is that the way the pattern charges?
I think you can just do take out the / and put commas and then put an and at the end because they're all felonies and just that's all you're telling them is that they're felonies for the purposes of that count, which is what the pattern requires.
So the offenses of malice, murder, aggravated assault, and false imprisonment as alleged in these counts
are felonies.
And we're deleting the top portion of that.
Yes. It's the same language other than mine just happens to be tailored to the indictment.
Okay. Any objection, Attorney Tillman?
I'm just reading this side by side.
Okay.
It appears to be appropriate.
Okay. Page 37, justification and use of force in defense of self or others.
The only thing I would say is, just, do you give a copy to the jury?
Well, I was going to ask, is there any objection I typically allow the charges to go back with the jurors. Is there any objection, Attorney Tucker, about the charges going back with the jury?
I was always on the presumption that the charges do go back.
Okay.
So since they're going to go back, on page 37, I would take out the parenthetical that says when deadly force is used.
Okay.
And which charge is it?
We're on
page 37.
Mine, I can't follow the page because of that, so I'm just basically trying to grab the space in mine. And put
justification.
It together. Okay.
Okay, so that is pattern. So is acceptable.
Acceptable by the state judge. With that one parenthetical taken out.
Right.
Which paragraph is that? I see the 37.
There's a paragraph, a little comment that just says when deadly force is used.
Right.
To give the part under. We're only objecting to the part that says.
When deadly force is used.
Yes. Just don't read that out loud. Just keep reading the whole charge.
Okay, moving on. Page 39, reasonable beliefs explained.
I'm stuck in my last one, Your Honor. What's the next one?
The justification and the use of force. Okay, so I am giving you an opportunity to re-review Attorney Tucker, so if there are any objections, you can always bring to the attention of the court and the state tomorrow.
Okay.
No objection to page 39, which is 3.10.12.
No objection. It is. It appears to be.
Okay. Page 40, no duty to retreat.
No objection.
No objection, Your Honor.
Okay. 41, threats justifying a homicide.
Pattern, no objection.
It appears to be the pattern, Your Honor.
Okay. Thank you. Page 42, excessive force.
Pattern, no objection.
It's pattern, no objection, Your Honor.
Okay. 43, revenge.
It's the pattern, Judge, but I think we would still need to take out the brackets on the 5th line, starting on the 5th line.
5th.
We would just say imminent death, comma, serious bodily injury, or commission of a forcible felony.
I'm not sure it's even that. I don't see where I heard anything about revenge. If the court wants to put it in there, it appears to be its pattern.
I can't hear you.
Okay. Your Honor, I'm not sure that revenge was brought up. I'm not sure it's necessary, but it does appear to be pattern. If the court would like to put this in, as long as it's the way it is pattern, I have no objection.
Okay.
I'm not sure the relevance.
He hit my car.
Revenge? Okay.
Okay, so there's no objection?
No, Your Honor.
Okay. 44, court has no interest in case.
Objection, it appears to be pattern.
Okay.
Correct.
Sympathy, page 45.
Pattern, no objection.
No objection.
46, responsibility for sentencing.
No objection. Appears to be pattern.
Okay.
Same.
47, deliberations.
Pattern, no objection.
It appears to be pattern. No objection, Your Honor.
Okay. Typically, I leave that towards the end of the charges.
It should be, Judge. So that was one of the things we indicated to Attorney Boga is that we had some issues with the order.
Okay.
So we definitely think this should be the end.
Okay. So, deliberations, responsibility for sentencing, those we put towards the end.
Yes.
So that would be page 44, 45, that court has no interest, sympathy, responsibility for sentencing, deliberations, unanimous verdict, we put at the end. Okay, bare suspicion. Page 49.
I don't know that it applies, Judge. It's a defense request, but we're not going to oppose it. It just needs to be moved. Generally, it's given somewhere near intent.
Okay, 1 second.
Or burden of proof. Somewhere near burden of proof. I think is
Burden of proof. Okay, so round about page 8, right after 18. We could make that page 19.
No, because all of those charges about the defendant's statement need to be together. So I would think it needs to go.
Okay, what are you referencing?
These bare suspicion
Bare
needs to
suspicion.
go.
Okay.
I'm just trying to find the right.
Right after directed circumstantial.
And we also have to place page 18, which is identification burden of proof.
I think that bare suspicion needs to go after page 7, which is after the burden of proof and reasonable doubt.
After page 7?
Yes.
Did you say bare suspicion after page?
After page 7. That charge generally goes around burden of proof.
And I agree with her on that.
So page 8?
Yes.
Okay. And page 50, proof beyond reasonable doubt, that should be...
That should be covered by the pattern.
Pardon me?
This should be covered by the pattern. This is not a pattern charge, so the state does not agree to this additional charge being given.
Was this the request by the defense?
It was.
Did we cover this before in this chart conference?
There is a charge up there with
prove beyond a reasonable doubt. But in this one right here, it basically takes the case on and puts the words in there that the true question in the criminal case is not whether it's possible the conclusion at which the evidence points to will be false, but whether there is sufficient evidence to satisfy the mind and consciousness beyond a reasonable doubt. Basically just following suit with the burden the state has, but it's worded different.
So we already covered that, I think page 6, presumption of innocence says burden of proof, reasonable doubt.
That is the state's position.
And it was a pattern charge.
And I'm trying to add to the pattern charge with a little bit better commentary, but it's at the court's decision.
So, I mean, it's just a different way of saying what's already there. So I go with the pattern charge on page 6. I'm going to delete it.
No, don't kill the play. We're just trying, Your Honor, and I understand the court's decision.
Okay.
It's just a different way of saying it.
It's, okay, on page 51, immunity or leniency granted witness.
I think that's
never been addressed.
I don't think so. Let me look.
Is this a charge you submitted, Attorney Tucker?
I thought it was addressed somewhere.
It was defendant's original request, at least from the 2022 version that I have. It was his charge number, request number 5. I think it applies, it's just in the wrong place.
Okay.
And so it is the correct place. Let me find it.
It could go where we deal with credibility of witnesses.
That is where it goes. So it should go...
Page 11?
Yes, it should go after page 11.
Okay. So that would be, we place it at page 12.
Yes, Judge.
Okay. Page 52, defendant's failure to testify.
That could be taken out. Maybe she did testify, so.
Okay. So that would be removed. Self-defense as an affirmative defense, that's page 53.
And as that charge has already been covered, and I noted in my notes that we would only agree to the full pattern charge. And this is not a pattern charge.
Okay, self-defense. So that's page 37, justification and use of force in defense of self or others.
We've covered it already. So this one paragraph is it's actually the statute. It's not the jury charge. So I think that the jury charge is what should be given to the jury.
The copy I have from my phone doesn't have pages on it, and I'm trying to find exactly where it is. I know it was addressed earlier. I'm trying to see.
It's a defense request to charge, number 11, but it is covered under justification of the use of force in defense of self or others.
Okay. If I have any objection, I'll make it
Okay.
tonight.
All right, so I'm going to take that one out because it is covered under justification and use of force in defense of self or others, which is the pattern. Page 54, prior inconsistent statements, substantive evidence.
So was that? What was the title of that?
Prior inconsistent statement,
Okay.
substantive evidence.
Just 1 second, Judge.
Well, it's such a cluster mess out here.
Judge, the pattern on this is actually currently only 1.31.47, which is prior statements. That should be, it was defense original request number 10. He requested prior statements and prior inconsistent statement together. But we're looking to see if that's still a current pattern charge about prior inconsistent statements.
Okay. While you're looking at page 56, I'm going to delete malice murder because we already have that.
Yes.
On page 30. And we already have felony murder, page 57. So I'm going to delete that. Causation.
Just if we can go back to where we were.
Okay. Prior inconsistent statement, substantive evidence.
I think that's been removed from the pattern, but we need some time to look at that.
Okay.
The charge that's still there that I can find right now, we can find right now, is 1.31.47, which is prior statements, which was also requested by the defense. Again, we'll look to see about the prior inconsistent and maybe visit that tomorrow.
Okay.
But either way, anything about prior statements or prior inconsistent is in the wrong place. That again needs to go near credibility of witnesses. So we can go after the immunity charge that we just added. But those are all about the same concept.
So I have the immunity would possibly be page 12. So you're saying page 13.
Yes, would be
the prior statements.
Prior statements and or the prior inconsistent statement. We've just got to look through the pattern when we can get to it more easily and maybe revisit that with the court in the morning.
Okay.
I agree it should be given. We just got to make sure it's still pattern, what's the pattern we want to give.
Okay. No presumption of criminal intent.
That's already been covered.
We're ready to go 56, 57. Causation in felony murder.
Already been given.
And firearm as a deadly weapon.
That was not given, but should be as part of the definition of aggravated assault.
Any objection, Attorney?
I agree with that, Your Honor.
Okay. And it's okay where it is?
No, it needs to be with the definition of aggravated assault.
Okay, hold on.
So it should be here, page 34. be that one little sentence can just be added to page 34.
Okay. Page 60, we've already dealt with justification and use of force in defense of self, so we can take that out. Correct?
Yes, Judge.
Yes, sir.
Same with 61.
Accident, page 62.
Judge, we had indicated we would want to be heard, but we withdraw any objection to that charge. The case law kind of indicates that should be given.
Okay.
But it doesn't go here.
Okay.
So we would need to, number one, remove the sentence that I have at the end where it says the state wants to be heard.
Okay.
And then we should put that near intent. Or after self-defense.
You might do self-defense. Well,
After page 37, justification and use of force in defense of self or others.
It would have to go, but it has to go after all of the charge, the full charge, which is
Right. 38, so
39, 40, it would have to go after 43. What's currently 43?
So what are we moving it after the name is the age of the number of the ten?
It would have to go after revenge.
what, the accident?
I thought you said you just wanted it after self-defense, but we can move it to after intent if you want.
I think that might be,
What now?
I think that might be more appropriate.
Move it to after intent?
Yeah.
Okay, so that would be moving it to
page 28.
I think Mr. Tucker wants to be able to look at it a little further and decide where he would want it.
Okay.
Because the one I was sent to me, looking at it on my phone, I had no page numbers to refer to it, and I'm trying to keep up looking at it. And
okay. If you do decide, then just
I will send
your
it
email.
tonight. I won't wait till the morning. I'll send it tonight.
Okay.
So if I get you right.
All right, page 63, involuntary manslaughter felony.
And
I didn't see you put that in there. I didn't see it in yours.
The state's contention that does not apply. That is a lesser offense that has no application in this case.
And I would like to reserve that I can look at it tonight. I don't see that it did in the first place.
Okay, I give you that opportunity.
Thank you.
No, we just have one last one. Page 18, identification, burden of proof. Just to place that.
We just need to figure out where to put it. It was just in the wrong place.
Right.
So you can put that. witnesses and DNA and experts, somewhere in that area would be what would make the most sense.
After page 24.
Yes. And that's for your reference, it'll be after the charge on DNA, put the charge in about identification of the defendant.
Okay. That completes what we're able to do this evening. And so we'll recess until we ask counsels, do you want to come in earlier at 8:30 and just review before, well, we're going to call rebuttal, so let's do it after.
Either way, Judge.
Yes.
I would, if I may make one note, just so counsel has the opportunity to look at what we're talking about. The court, as it related to when we were talking about prior statements of a witness and prior inconsistent statements.
Yes. What page is that?
I'm about to find it again. You actually are giving that charge on page 14. I didn't realize that when I was asking the court to talk about it tomorrow. That charge is already being given.
Prior statements. Okay.
Yes. The defense request is prior inconsistent statements, and that is no longer a pattern charge.
So it's already given on page 14.
Just prior statements. The pattern used to distinguish between prior consistent and prior inconsistent. The new charge just says prior statements. No, it's in the right place. It's already, I indicated to Your Honor that we needed to talk about it, but it's already being given. I want to note that if counsel still wants you to give prior inconsistent statements as substantive evidence, losing the ability to talk at this point, it is not in the pattern. So I'm just indicating, because it's not pattern, we don't agree to it, to give counsel an opportunity to look it up, make whatever argument he wants to make tomorrow.
Okay. All right, that's fine. Because the indication is that it's already given on page 14.
Part of what we requested is already given, not completely.
Okay.
All of what I requested is given, not all of what defense requested is given.
Okay. All right. So we're going to recess at this time. Thank you to everyone for all the hard work. Thank you to our bailiffs and our deputies, our court reporter and transcriber who have stayed behind at 6:30 to get this done. So we resume at 9 o'clock tomorrow. Thank you, everyone. Everyone, please get home safely. Get some rest.
Thank you.